Yeah, great petition, my lord. It's under Water Act, my lord.
My lord, the Gram Panchayati the election has been fixed on day after tomorrow, 5th, my lord. They have issued. We have challenged the single bench order. Gram Panchayati election candidate president. The actually no confidence resolution has been passed. The election of the Adhyaksha has been fixed on day after 5th. I complied all of his objection, my lord. Since in view of the urgency, it may take tomorrow, my lord. But Adhyaksha post has been, the day the election has been fixed on day 5th, my lord, 5th of March. 5th of March date is been fixed. Please. President of that. But I challenge the single bench order, my lord. So it is tomorrow. Tomorrow may kindly.
The order of the single
Submission, my
judge.
day after tomorrow, please. 4th, my lord, please. Because purpose of 5th lordship. 4th, please. Please.
Challenging the order of the learned single judge, refusing my writ petition, my lords. There are civil suits pending. My apprehension is that the revenue entries might be changed basis of the dismissal. It may be had on Thursday, my lords. There's some urgency, my lord.
I am
Okay.
seeking adjournment in serial number 87.
This is a commercial appeal which I have filed, my lord. Commercial appeal which I have filed based on the commercial suit. I'm placed ex parte in the commercial suit. I'm the defendant in the commercial suit. The plaintiff is likely to file a execution petition, my lords. Kindly, it may be heard any convenient date. Please.
My lord,
It's number 32, my lords. I'm the appellant in commercial appeal, my lord. It's number 32, my lords. 32, my lords. May I prefer next week, my lords? Lord, interim order has been granted earlier. It may kindly be continued till the next date of hearing, please, my lord. Please, my lord.
My lord,
Obliged.
serial number 36, my lord.
my lord, my lord, this matter pertains to a mining.
Number 4 is covered by judgment, my lords. It doesn't survive for.
My lord, serial
My lord.
number 118 to 120.
My lord, this matter pertains to a mining industry. I had applied for a lease for a quarry, but my application was rejected, and the respondents have subsequently issued licenses to other individuals, my lord. Hence, I have filed the writ petition, and the same may be taken up, my lord. Any date fixed by this honorable court.
My lord, serial number 118
Much
to
obliged, my lord.
125. 118 to 125. Kindly may be posted on 10-3 as there is a connecting matter. 118 to. It's a willful disobedience by. It's a.
Why do you want
It's a connecting matter. There's a connecting matter.
Connecting is coming upon?
10-3.
At the request of up to 125. Up to 125.
118 to
At
125.
the request of learned of the complainants, then over to common order will do.
My lord,
10th of March, since it was stated that the similar connected contempt petitions are slated to be posted on that day.
serial number 58, my lord. Serial number 58. Contempt may be dropped, my lord. They have complied with the order. Serial number 58, my lord.
What do you want?
Contempt may be closed, my lord. They have
Learned
complied with
advocate
complaint.
Balraj has stated that the contempt does not survive as the order is complied with. He requested the court to close the contempt proceedings in view of the statement, dismissed does not serve. The petition is dismissed does not survive.
My lord, serial number 106, my lord. Serial number 106. I appear for petitioner, my lord. May I seek for a short accommodation in this matter, my lord?
This is a PIL of 22.
Please, my lord, my senior, my lord, is suffering from ill will, my lord. He is suffering from ill health, my lord. That is the reason, my lord, I am seeking adjournment.
Yeah. What is that? What is it about?
My lord, illegal construction, my lord. My lord, the respondent number 13, my lord, constructed a commercial building in the buffer zone, my lord, for which no permission can be granted. My lord, in spite of that, my lord, the respondents have granted permission and the construction has been completed.
Second April, as requested.
Grateful, my lord.
Lord, serial number
Lord.
60, my lord.
Yes. Anybody?
Serial number 60.
It will be posted then. Wait for. It will be posted by the office. 27th March.
Pursuant to the order of objection of my expedition, the respondents are putting up the construction in my property.
20th March.
My lord, serial number
Then
28.
they're putting up the compound one. This week, my lord.
Will demolish the company.
My lord, serial number 28, my lord.
Lordship, serial number 113, 113, Lordship, serial number
113. 3.
Lordship, needful done in the, during the course of the day, Lordship. This is an process in
4th April. As requested.
My lord, serial number 60, my lord.
60.
60, my lord. For the accused in this matter, my lord. My lord, week's time have been granted, my lord, in this matter. I have filed an objection to the.
Time.
Please, my lord.
24th of March. As
Obliged.
requested. by learned advocate.
Lordship. 113 interim order may be extension.
113 interim order based.
Please.
Interim order already operating shall stand extended till the next.
Number 99, and for the respondents, it maybe had after 4 weeks. The other side has filed an IA. Try to file my objections, it was only filed last Thursday. 99 maybe had after 4 weeks, 99.
4 weeks.
After 4 weeks.
Petitioner has no objection.
Sorry,
Appellant has no objection.
Appellant has no objection. I'll inform her. I'll inform. They anyway filed their IAs last Thursday. I'll file my objections to the same.
Where is the appellant?
The appellant is not here.
Then first inform them. Then mention at 2:30.
My lord, serial number.
Or intimate the court officer if he is consenting, then
Please,
we'll grant. Yes, Mr.
Serial number 28, my lord.
28.
Settlement talks is going on, my lord.
What is it, 28? Company. Why everybody is? Settlement is going on. 39-1-2. Order 39, rule 1. Shall we record that settlement is going on?
Please,
Learned advocate Mr. Sravana S. For the petitioner stated that time may be granted since the parties are engaged in the settlement talks. Full stop. In your such request and over to 24th March. Please.
Serial number 36.
Serial number 111, my lord, 111. It's a commercial appeal against the refusal to grant an ex parte relief in Section 9 application. In view of the urgency on Thursday, the bench had permitted us to serve by hand, which we have done, and we have filed a memo of service and affidavit of service in compliance. In view of the urgency, your lordship may take that as served. They have also asked us to pay PF for regular notice, which I have done today. There is grave urgency. If it could be heard today, my lords, on the ex parte relief, I have served them.
You serve tomorrow. Wait for a day.
Please, Mons.
Tomorrow.
Deeply obliged. Grateful.
Today is
My lords, a humble submission, my lords.
Today is third. So tomorrow, fourth.
My lords, writ appeal 951 of 2024, it was listed on 28th, my lords.
My lordship, for the matter of commercial appeal, my lordship, and this, the respondents' partners are trying to alienate the property, my lordship.
It will be only office.
My lords, writ appeal 951 of 2024, I'm for the appellant. It was listed on 28th, my lords. The opposite side had filed an IA for clarification. The same was deferred on 28th itself, my lords. But the said order is not uploaded on the website. The registry may be kindly directed to 28th of February, my lords.
Don't mention, it will be uploaded immediately.
My lords, there's a
2 days. We
much
know that urgency, more than you.
much obliged.
What kind of mentioning or mention?
My lord, serial number 6.
Must have been uploaded by now, Mr. Counsel. Yes.
I am appearing for the complaint in serial number 6, my lord.
Yes.
2 weeks time may be granted.
Which one?
Serial number 6.
Serial number?
This is with 6, my lord.
Why?
My lord, this is with regard to a civil disobedience by the court commissioner. This is with regard to the first report. The court commissioner has already filed the second report. So we are inspecting the same. We'll come back with necessary submissions. 2 weeks time may be granted.
It's a contempt petition.
Yes, my lord.
Then let us wait. Let it be called up. Yes.
Your lordship, serial number 16, your lordship. I appear for respondent number 6. I
Yes.
seek for a short adjournment, your lordship.
Why?
Your lordship, senior is gone for mediation training, your lordship. So she's not there.
Then this matter also can go for mediation,
Your lordship.
along with the senior. Anyway, when do you want? 20th March.
Any obliged, your lordship.
Your lordship, serial number 9. I appear for the petitioner.
Yes.
I seek for a week's time, your lordship.
No.
Your lordship, senior is currently
Senior
maintaining ill
Gone
health.
for, senior has gone for mediation.
No, your lordship, senior is currently maintaining ill health. This is a fresh matter, PIL matter.
No, let it be called up. We'll see when it is called up. No time right now. Yes.
Obliged.
Kind permission. So contempt matters, seal number 1, Mr. Sridhar G.
Notice returnable on 27th March.
Seal number 2.
Please,
Sir,
my lords, for
Trivikram.
the complainant, my lords. Lords, the order of the learned single judge, my lords, dated 21st June 2023 has not been complied till date, my lords. Subsequent to the order, my lords, I had made a representation.
The direction of learned single judge in order dated 21st June 2023, while disposing of the writ petition is to require the number 4 Tehsildar to take appropriate action according to law in respect of the application of petitioner for conduct of body. Full stop. The direction is to undertake the body expeditiously. No time limit is prescribed by learned single judge.
May I mention, my lords, subsequently I have made a representation, my lords, mentioning the time frame. If your lordships are pleased to come to page 24, my lords.
Where is that?
Page 24.
That's
From the bottom, my lords, fourth
notice
line, my
not-
lords.
That is
50 days.
that is the very correct course of action. Notice returnable on
Grateful,
21st March.
grateful.
Seal number 3, Mr. Srinivas.
For the complainant. Not the order was passed in the writ petition was on 30th/11/2020, where the direction was issued to the accused to hold the inquiry and to pass the necessary orders according to the findings of the inquiry officer. And further directed, all the consequential benefits, will be payable to the complainant will be depending on the findings of the inquiry officer. Thereafter, the inquiry was held by the inquiry officer and findings was submitted, on 12/1/2023, Thereafter, the consequential benefits, which the in the inquiry, it was held that the complainant has not committed any misconduct. Hence, the respondent accused was required to pay all the consequential benefits to the complainant. But in spite of, my lord, repeated representation and even a direction by the chief executive officer, my lord, was also issued, my lord, to the accused herein, thereby directing him to pass necessary orders on the request of the complainant. Lord, the representation, my lord, given by the complainant, my lord, at annexure F and G, my lord, have not been, my lord, looked into by the complainant, the accused. And, my lord, the consequential benefits have not been paid.
When you are, after 4 years, you are coming.
My lord, the lordship may kindly see, my lord, the inquiry, my lord, was concluded on 12/1/2023.
No, your statement was to occur before inquiry.
No,
No?
I was there, once again, my lord, removed from service. Annexure B is the second order passed by the Sambu court, my lord. Annexure B, my lord, is the order. Once again, I was, my lord, suspended from service without holding an inquiry. My lord, once again, I approached the Sambu court.
So what is the contempt? You are not reinstated.
I have been reinstated, my lord. The issue, my lord, is only regarding payment of consequential benefits as directed in the last para of the order. My lord, para 6.
Is returnable on 27th.
Grateful.
So 4 is urgent number 5. Mr. Mohammed Rakib.
Hearing on behalf of the complainant. Lordship, the Lordship, the respondents have willfully and deliberately disobeyed the order that has been passed in WP number 16063 of 2024, Your Lordship, which is given at page number 15. We operate a legal poker club, Your Lordship, which is being harassed and threatened that such operations will not be allowed. After obtaining such order in the writ petition, Your Lordship, on 13/9/2024, an FIR has been filed suo motu by the respondent police, in which they have invoked the sections 79 and 80 of the KP Act, Your Lordship. This particular FIR, Your Lordship, has been challenged before the Honorable High Court, and immediately on 17/1/2025, we have obtained a stay on the same. Despite that, Your Lordship, another FIR recently during the pendency of this civil contempt petition also has been filed by the respondents, Your Lordship. On FIR number 56 of 2025, Your Lordship, on 14/2/2025.
What is breached?
Much.
What is breached? What is the breach?
Lordship, they are not allowing the lawful activities of the club, Your Lordship. In the FIR itself, they mention that poker is being played.
See the last direction. Order would not come in way of the jurisdictional police to invoke the provisions of the Act and taking action in accordance.
Absolutely, Your Lordship. But however, the action is under the misinterpretation of the law that somehow poker as a game of skill also falls within the ambit of KP Act, Your Lordship. And that being...
By disposing the matter, my lord, there was a liberty given by the Honorable Court of Judicial Police matter, page number 6, my lord, page 20, my lord. By disposing of the writ petition 1063 of 2024, my lord, the relevant portion, my lord, page number 20. There is also liberty given by the Honorable Court, my lord, the judicial police shall have the liberty to visit premises periodically on receipt of any information about any unlawful activity being carried out on in the premises. Not that now and time and again they are visiting, my lord. As and when the information is obtained, my lord, the judicial police are visiting the premises and checking the activities of the petitioner. That liberty was given. So there is no such thing called breaching of the order, my lord.
There is no other offense that has been mentioned in the FIR also, Your Lordship. Lordships. There is no reason for them to initiate any proceedings when there is an absence of any offense that has been committed in the club premises, Your Lordship. There are specific directions that have been passed by this Honorable Court, which are being complied in letter and spirit, Your Lordship. Only members are conducting the recreational activities within the club premises, Your Lordship. The FIR and the subsequent FIR, even after being stayed by this Honorable Court, shows an abject disregard of the Honorable High Court.
There is no mention of subsequent FIR.
Subsequent FIR, your lordship.
In your pleading, there is no mention.
Lordship, because this has happened during the pendency, your lordship, and we are filing it along with the memo.
So no contempt is committed. No contempt is. What contempt? You are doing as per the liberty granted.
Liberty is granted, your lordship.
If you want to challenge
for-
those actions, you can independently challenge, but there is no contempt. We already challenged the.
We have
FI.
challenged it, it is stayed
FI.
already, your lordship. But despite that, the visits of the respondent police on multiple occasions and disrupting the games and intentionally threatening that we will not allow this to continue and will file in
Take out-
multiple proceedings
you are
against
Take
you.
out separate proceedings. If at all you are entitled. No contempt
Kindly.
is coming.
Lordship. Lordship. And it is our submission, your lordship, that if they undertake any search and seizure based on the misinterpretation of the law, which has been clearly decided by the Honorable High Court in the WP, then that also would amount to contempt, while they are aware of the WP, and they have just now pointed out also, your lordship, and they are aware that poker as a game of skill has been designated as such by the Honorable High Court on multiple occasions. There is no other mention of any other game of chance or how it falls within the ambit of section 79 and 80 of the KP or Act, your lordship. Otherwise, the actions of the respondent police would absolutely go unchecked, because the only recourse that we have against them is getting a stay against them, and their reasoning is not mentioned in the entire complaint or the FIR or in their subsequent seizures, which are in effect disrupting the.
So you want you invite order, then we are not with you. You invite order, we are passing to start. Yes, heard learned advocate, Mr.
Lordship, if it may be adjourned.
It can't be adjourned. The disclosing of mind that we are not with you is only to permit you to exercise an option, which you know what is the option.
Liberty may be granted, your lordship.
What liberty?
Lordship. Will withdraw the point number 7 is being in the WP, your lordship, on page number.
Heard learned advocate so and so for the petitioner, and learned additional government advocate Raghavendra, who appeared upon service of copy of the petition in advance. Full stop. While disposing of the writ petition as per judgment and order dated 25th June 24, alone a single judge issued the following directions. And quote all the directions. Page 18 starts 1, 2, 3, 4, 5, 6, 7, 8. Full stop. The directions indicate that the petitioner is required and directed not to permit any activity and of its members by indulging in the acts of amusement under section 214 and 215 of the which act? Karnataka Police Act 1963. The petitioner is directed to put a proper mechanism to ensure that no game is played in any unlawful manner. Full stop. The breach, the other obligations are also cast on the petitioner while running his activities. Paragraph. The contempt is alleged, more particularly in respect of conditions number 6, 7, and 8 of the order aforequoted. Full stop. Thereunder, the jurisdiction police is granted liberty to visit premises of the petitioner periodically. and upon receipt of any information about unlawful activity carried out in the premises of the petitioner, take necessary action in law. Full stop. While the respondents are directed not to interfere with the lawful recreational activities of the petitioner's company, it is equally made clear that the order would not come in way of the police to invoke the provisions of the act and taking necessary action in accordance with law against the members of the petitioner. If the petitioner is found to be indulging in the immoral or unlawful activities, full stop. In the present contempt petition, the case of the still there is a chance.
Lordship,
Become wise.
yes, sir, Lordship. Lordship, on the basis of the writ appeal that this WP has been passed, Your Lordship, in that writ appeal, there's a specific provision that says that the jurisdictional police
What did you write?
are directed not to interfere with the lawful recreational activities carried on by the members.
Petitioner is that
Lordship, I'm just, there's WA 728 of 2020, Your Lordship. I am just handing
that
over
the
the
police is
citation, Your Lordship.
unnecessarily interfering with the
Unless-
activities of the petitioner,
Yes, Your
and
Lord.
that there is a breach in that regard,
Breach in
as
that.
the petitioner is not permitted to carry on its recreational activities. Full stop. From the record, it could be seen, and it is also admitted in the evidence that an FIR is filed against the petitioner by the police authorities concerned, which FIR is registered as hearing number 318 of 2024, dated 13/9/24. The directors and the employees of the complainant company are arraigned as accused. Full stop. The FIR is under section 79 and 80 of the Karnataka Police Act 1963. Full stop. It was filed pursuant to raid conducted by 25 to 30 police officers at the premises of the complainant, which is situated at 62, 5th floor, 43rd Cross Road, Jayanagar, Bangalore. The director of the complainant was was found to be indulging into, allegedly found to be indulging into the unlawful activities. Full stop. The complaint, after the date of the passing of the order, it appears that after the days of the passing of the order, PSI of the Jayanagar police station has addressed a communication dated 13/9/24 in PSI Jayanagar police station has addressed communication dated 13/9/2024, wherein he has requested the police sub-inspector address, wherein he has requested the police inspector of the said police station to take necessary legal action against the persons who are involved in the illegal gambling in poker club. Also the poker club, which is the petition, which is poker club of the petitioner named as Messrs Gold Pyramid Private Limited, was noticed to be indulging into unlawful activities and immoral conduct through the directors and the employees. The allegations are contained in the FIR. Full stop. It is on the basis of the concrete information, paragraph. It is on the basis of concrete information and in accordance with law that the police authorities has taken action against the petitioner by filing FIR. In course of the hearing of the petitioner, the honored advocate stated that even the second FIR is filed. Full stop. This aggravates the situation. Full stop. The contempt petition is thoroughly meritless. No contempt is committed. On the contrary, it is observed that the police authorities shall take stern action against the petitioners who is, if found to be indulging into, if proved to be indulging into unlawful and immoral activities in the name of amusement and recreational activities. Petition is dismissed.
Number 6. So Vivekananda HS.
Appearing for the complaint in this case.
You
Lord,
want
this
to
is
try?
with, yes, my lord, this is with regard to a commissioner's report filed in OS number 79 of 2022. A second report has been filed, my lords.
What
We
is
are
the
inspecting the same. A week's
But then
time
what-
may be granted to,
But what is the contempt?
my lord.
What is the contempt?
My lord, this is the complainant herein instituted a suit in OS number 79 of 2022 for a bare injunction. The learned trial court, after hearing, granted an interim order. Agreed by this, the defendant filed an miscellaneous appeal in 39 of 2022, granting status quo. Later, agreed by the same status quo order, the plaintiff filed repetition in number 19172 of 2022, wherein this honorable court was pleased to order appointment of a court commissioner. This can be found at Annexure A, my lord.
You are traveling in a bullock cart. We want what is the directions which are not complied with. You must
My lord,
fly
this
by air
honorable
and
court,
come to the point. Yes.
my lord, the learned trial court appointed the court commissioner, and then after an
So
inordinate
it is,
delay,
on the contrary, the directions are being complied with. As you are saying that first
my
report
lord,
is already aware.
we are challenging the way the inspection has been carried out. Kindly come to page number 79, my lord.
79, yes.
My lord, this is a notice, a letter of intimation given to us by the accused, intimating intimating us to participate in the local inspection. Your Honor may kindly look at the date. The date is left blank in the 5th line, my lord. The date of inspection has been left blank, and
Then what is the contempt? He will conduct the inquiry, court commissioner. He will conduct the local inspection.
my lord, we are challenging the way the local inspection has been carried out. It has been carried out without even informing the plaintiff in the said suit.
Then you can complain to the court below.
My lord, a
Difficult
week's
to
time may be
conclude
granted. My senior will address the issue, my lord. 2 days
It
time
is
may be.
stated that you are to be informed. You are bound to be informed, but where it is stated in the directions that you are supposed to be informed.
Well, kindly come to page number 80. The translated, I have furnished the translated copy of the letter of notice. Here, the date of spot inspection has been left blank.
It is all right, but it can't be said that there is a contempt. We will put off the matter for a week and then see what happens.
Please, ma'am.
So we will stay at 2:30 on 19th March, since the learned advocate petitioner stated that the report of the court commissioner as directed is awaited. Correct?
Obliged, ma'am.
Yes.
It's PL matters, cell number 7 to B Vishweshwaraya.
Happy for the respondent. Lord, my instructions is that, my lord, as of now, the concerned officer has come and he's stated that, my lord, the learned single judge, he is hearing this matter and tomorrow it is for final hearing is what he says. There is another petition challenged by the company is what he says, my lord. Yes, my lord, insofar as Union of India is concerned, my lord, we'll have to put it on record. We have got the instructions, my lord, as
You are saying that you had some issues, some guidelines or policy.
please, my lord, that guidelines, my lord, is national guidelines on lactation management center in public health. I'll have to place it on record, my lord.
Learned Additional Solicitor General, Mr. Kanti Bhushan wants time on 2 grounds. Firstly, it was stated upon instruction that they connected writ petition, that the writ petition involving the similar subject, which is writ petition number
19352 of 22, my lord.
352 of 2022.
Please, my lord.
Is being considered and heard by learned single judge. Secondly, it was stated that there are some guidelines issued by the Union of India in relation to the commercial dealing with the breast milk, which he would like to place on record. Full stop. Permission is granted. The time is granted.
One submission, my lord.
The petition to be listed on 21st April.
Great.
One submission, my lord. Let those writ petition may be tagged along with this PAL, my lord, so that it will be easy for.
Let it proceed. It is already being proceeded with.
Please, my lord. Great.
Cell number 8, Mr. Manjunath.
My lords, the petitioner has filed this PAL by challenging the order of the Deputy Commissioner of Bangalore Urban, my lord, where Deputy Commissioner has passed an order. My lord, may I request you kindly refer the Annexure A, my lord, where the Deputy Commissioner has passed an order, my lord, to deviate the alternation of the causeway, that is called.
Where is that?
Yeah.
Page
number 51, my lord.
51. 51. 50.
Page number
50, yes.
Where they clearly says that, my lord, in the proposed lands, survey number 77, and so kuntas, my lord, totally 24 kuntas of land has been diverted, my lord.
Land is diverted or water course?
No, water, causeway, my lord, that's water course.
It is a water course.
Yes.
Where it is stated, let us see. It is stated about the diversion of Kharaba land. Path of the big Kharaba land of canal.
Canal, my lord, that's a water.
Canal.
Yeah.
For what purpose?
The purpose is, my lord, the developer has requested them to, as per the law, my lord, the developer has requested them to divert the land and by relinquish the other lands, my lord. That is provided in the act, my lord. But here the concern is, my lord.
No, why water course is diverted?
They are building this one, my lord. They have built the, they are the builders, my lord. They have built the apartments and all that.
Any photographs are there?
My lord, I'm just challenging the order of DC, my lord. DC doesn't acquire the power to do that, pass this order as per the law, my lord. So as per the law, it clearly says that only the value which is below the 1,000 rupees, only DC can pass the order, such kind of orders, my lord. Here, the value of the land is more than 3 crores, my lord. That as per the law, it should go.
First show us that there is a diversion of water course for the purpose of constructing something by the builder. That is your case.
Yes, ma'am.
That the water course of the canal is diverted.
Yes, ma'am.
Because the builder wants to construct some building.
Already constructed.
At the place where water course is flowing.
Please, ma'am.
So you show us where, how can we know from this? Any photograph, anything? And anything from order? land subjected to the change path should be reserved for public purpose. So how, when whatever the path is changed, if the path of the land of canal, how can you change the canal if it is right?
My lord, I'll seek instructions and make my submission. My lord, the order is of the year 2019, my lord.
2019?
Yes.
And my lord, even today, so such kind of order is passing, my lord. Even today, DC is passing the orders for the more than the value more than 1,000 rupees, my lord. So that's the reason we have also filed another 2 PIL.
That to 2019 and we are in 2025. And this order is appealable under section 49C to the tribunal.
Which tribunal?
My lord, the Karnataka appellate tribunal. But I can get information, my lord, and place it before my lord if my lord were to grant me some time as to what the actual situation is.
Will not issue note.
So
We will find out. 19th March.
Obliged.
my lord, I will arrange the photography as well.
We do not know. We have done nothing except asking them to.
Case number 9,
Copy could-
Mr. Ojasvi.
Correct.
Your Lordship, I appear for the petitioner in this case. I seek for a short accommodation, Your Lordship.
Why?
Senior is keeping bad health.
Like what?
My lord, the Panchayat Development Officer, they have made a request to them with regard to illegal construction of an Kalyana Mandap, my lord. Just a representation.
Only prayer is to decide the representative.
Please, my lords.
You can do that.
Your Lordship, I am a proxy counsel in this. It may be posted next week.
1st April, as requested by learned petition.
Case number 10, Mr. K. Abhinavanan.
My lords, the sixth respondent is the owner of land in survey number 23/1, measuring 5 acres 10 guntas of H. Basapura village within Algur Obli, Malvalli Taluk, my lord. She got it converted into non-agriculture purposes for the purpose of formation of private housing layout. And the deputy commissioner has accorded permission for formation of private layout. And as far as private layouts within the limits of Panchayat, my lord, according to the departmental rules of Panchayat Raj and Rural Development and Panchayat Raj institutions, the land situated within Panchayat limits come within non-planning area. So for formation of layout for non-planning area,
It must have layout is there.
for the last, it was,
You are seeking to comply with some conditions of the order of April 15,
blood,
10 years.
technical approval was granted in their 2015
When?
for formation of layout within 2 years. And despite the guidelines and conditions as per the technical approval given by the Joint Director of Town
This is
Planning,
residential layout.
residential.
So what conditions are not complied with?
The officers concerned, my lord, Panchayat Raj institutions, they have to direct the sixth respondent to comply the requirement of providing.
Which requirement is not complied with? You are asking us to direct the authorities to comply with the requirements contemplated in technical approval dated 24/4/15.
Please.
So we are asking that what is not complied with?
That is the formation of construction of water drainage and overhead tanks. Roads, construction of drainages.
Who are you?
He is a petitioner, is a public spirited person, my lord.
That we know because it is public interest. In all public interest petition, petitioner a public spirited person. That much we know. But who are you in life?
So the site purchasers,
Site purchase.
he
So
is not,
interest-
he is not a site purchaser, my lord. On behalf of the site purchasers.
On behalf of site purchase.
On behalf of the site purchasers. he
So
has
what
filed.
interest you have got?
No personal interest. my lord. He has no personal
So then
interest.
site purchasers come individually if they have some grievance.
Only because the purchasers are middle class and poor class people, they are unable to approach the courts.
The fact that they have purchased the site also. The fact that they have purchased the sites shows that they are financially capable persons who can approach the court to read. It's purely a dispute between private parties. Where is public interest involved over here? See, your case is a private individual. What is the extent of 5 acres, 10 gundas of land? After obtaining the necessary permission, converts it for non-agricultural purposes, forms a layout and has alienated it in favor of individual private persons. If he has violated any of the obligations, they are at liberty to sue him. Where is the question of public interest over here?
I may kindly be permitted to withdraw the petition.
Learned advocate in course of the hearing, 6 permission to withdraw the petition. Dismissed as withdrawn.
Seal number 11. VR Datta.
Please, minutes. But this is a matter pertaining to the Honorable High Court's record to be maintained and preserved, my lord. But whereas the timeline which has been given, my lord, all the original the documents which have been required to be preserved, they are being destroyed, my lord, after 5 years.
But we have got this is in accordance with the rule 3.
Yes, I have challenged the rules itself, my lord, because they are in conflict with the rules of the Supreme Court, my lord, which they have framed. Because as your lordship knows, Supreme Court is also court of record, and we are this honorable court is also court of record.
What does the Supreme Court rule say?
Kindly see, my lord. Your lordship will kindly turn to page 23. Annexure A, my lord. This deals with the destruction of records, my lord. Rule 2, the record in such case shall be divided into 2 parts. Part 1 to be preserved permanently in physical, digitized, scanned, microfilmed, or such other form as may be decided by the Chief Justice of India. And part 2 to be preserved for period as hereinafter provided, my lord. Now, next page, your lordship will kindly see the part 1, my lord. The following papers shall be included under part 1 to be preserved permanently, my lord. Index, judgment, decree or order, pleading, plaint, written statement, set off, counterclaim, petition of appeal, reply in petition of appeal, rejoinder to the reply, statement of case, original petitions, including admitted special leave petition, Article 32, and so, my lord. Reference received under Article 143, reference so and so, memorandum of compromise, award, arbitrators, original documents, papers or historical, sociological, so and so, my lord. Whereas our and other papers which have been mentioned up to 16, my lord. Whereas in Rule 3 of the Part 20 of our rules, my lord, kindly see, in Rule 3, the following documents shall be preserved permanently. It only says all judgments, final orders, autographs, and decrees of all the cases except orders summarily dismissing the appeal or the application, all registers of appeals, petitions, including writ petitions and applications. So this is being interpreted to say that it is only all the registers of the writ petitions, etc. is to be maintained.
Where did you read? Where are you reading?
Page 27, your lordship will kindly see. Page 26 and 27. Annexure B.
That is the High Court rules, yes.
Please, my lord. Yes, I have called out the High Court rules in part 20, chapter 20, my lord.
So Rule 3, following documents and papers.
Yes, following documents. Only it says all judgments, final orders, autographs and decrees of all the cases except orders summarily dismissing the appeals or applications, all registers of appeal, petitions, including writ petitions and applications. My lord. Now this ought to have been writ petitions and this one, but they interpret it as only registers and all such papers of historical and all other matters.
No, you are reading actually judgments, orders. That is
Please, my lord, that is one. There is no difficulty about that. That also in the Honorable Supreme Court.
Shall be preserved for 5 years.
Please, my lord.
Then which clause you are reading?
Preserve permanently, my lord. Preserve permanently are all. Now compare this with the part 1 of the Honorable Supreme Court, my lord, rules. It says index, judgment, decree or order. So they are not, then your lordship will come to, sorry, my lords. And
so under Supreme Court rules, the documents which are reserved here for 30 years and 5 years are permanently.
Yes, my lord.
But we have got a rule committee this.
No, your lordship may kindly defer the matter and please it before.
Will issue notice.
Please, my lords. I am grateful.
So that something can be.
Please, my lords.
Something can be worked out in the direction.
Please, my lords. Please. In fact, my endeavors is, my lord, what happens is, my lord, these are the matters because it's a court of record. May I also pass on the judgment wherein the Honorable Supreme Court has said, what is the meaning of court of records, my lord? May I pass it on?
We have seen that it is very well drafted petition.
I am grateful, my lord.
Salisbury laws and that is in court of record. Well,
Please, my lord.
Well drafted.
I am grateful, my lord.
But
my only request is that at least.
It might have some time consuming solution.
Please, my lord, I'm not saying, I'm only requesting, my lord, at least stay may be granted till this my matter is finalized, because what happens is all these documents, the other day, my lord, when I gave the representation.
It may not, stay may not arise for this reason. They have produced some photographs pointing out, my lord, that they are ready for destruction. These are, my lord, very old photographs. These,
No.
after
We have
calling for
taken on,
tenders.
I have mentioned it, my lord, 17-1, that is when we have filed, we have inspected in December and given the photographs, my lord.
My lord,
It is not so.
You are for High Court?
Yes, my lord. After tender process, my lord, these were shredded and my lord, they have been disposed of. There is no such my lord, records as on today what they have shown. And my lord, it's an ongoing process, my lord.
It's a continuous process.
Yes, it's a continuous process. Next time, my lord, I have to again call for a tender whenever, my lord, the bulk of the
Present tender period expires.
My lord, as of now, my lord, there is no destruction that is actually happening. Therefore, my lord, in the meanwhile, we'll place our my lord, objections to the petition also.
My lord, indexing is a daily affair.
Five years.
But our anxiety is that the suits may go on, where the appeal may have been filed in the High Court. Suits are pending in the trial courts. And naturally, suits are going to last more than 5 years. And in the meantime, if you.
My lord, there is a provision, my lord, which indicates, my lord, if there are.
Of course, we know that is also something to be done on administrative side. Not entirely on judicial side, but still there is something to be worked out. Either on administrative
Lord,
side
in the
or
2013 Supreme Court rules, my lord, which are of recent origin compared to our rules, they've provided for digital, one option is to keep them digitally saved. Possibly when these rules were made, that provision was not there. So we have a problem of storage. We have in the 3 record rooms, which are filled. And what is being destroyed is the 5 years, what had to be preserved only for 5 years.
When we are considering on judicial side, it may not be a good answer that we cannot store. On
It's a
administrative,
court of record, well, permanently it has to be maintained is what the Honorable Supreme Court says.
on administrative side, yes, that there is a storage, we know. But when we are considering on judicial side, this is thoroughly irrelevant.
No,
How
all
can they
the
make a
times,
statement like that?
But even if it has to be an amendment to the rule, as said, it may go before the committee. But digital saving, is something which also could be considered.
But till then, my lord, I'm only submitting, let the Honorable Court consider this by placing it before the committee. But in the meantime, let it not be that the destruction take place. As it is since, because as I know, my lord, in Bombay High Court, my lord, since 1862, the records are available.
56.
Third learned
33, one minute.
senior advocate, Mr. So and so for the petitioner. Learned advocate, Mr. Senior advocate, Mr.
Sriranga.
Sriranga for this number 1. From a learned Additional Solicitor General of India, Mr. Santi Bhushan for this one 3. And learned advocate, learned additional government advocate. Srimati Nilofer for this one 2 state. The petitioner who is a practicing advocate in the High Court, seeks a prayer by filing this public interest petition, present public interest petition, to set aside the amendment to the High Court of Karnataka Rules 1959, in particular Rule 3 in Chapter Roman 20, capital. The said rule permits destruction of record available with the High Court after 5 years.
It was not called.
While making prayer, paragraph, to set aside the aforesaid rule, it is the case of the petitioner inter alia that the High Court also, like the Supreme Court, is a court of record. Under Article 215 of the Constitution. Full stop. It was submitted that the Supreme Court under Article 129 as a court of record has framed rules which provide to preserve the record permanently. It was submitted that the rule 2 and 3 of the Karnataka High Court rules which permit the destruction of record at the expiry of period of 30 years and 5 years respectively, not only run counter to the purpose, but stand inconsistent with the concept that the High Court is court of record and that the record has to be preserved permanently for larger interest of administrative justice. More particularly when the decision in the cases get delayed for various reasons. Paragraph. The court is aware that the issue raised has also an effect on the administrative side. However, in order to arrive at appropriate conclusion in respect of the case of the petitioner. From a notice is hereby issued, the respondent who shall respond to the issue raised and asks the court in course of the hearing of the petition.
May I serve the copy?
Notice shall be returnable on 19th of March, full stop, that day. Respond number 1. Shall put up the necessary facts before the court in relation to dealing with the record, which is otherwise to be disturbed at the end of 5 years.
May I serve the copies of the respondents, my lord? Your lordship may direct. Copies to be served on the respondents, my lord.
It is permissible for the counsel for the petitioner to serve a copy of this petition to the respective advocates for the respondents.
I'm grateful, my lord.
Great.
It's my lord's property, my lord. It's my lord's property, my lord, the Honorable High Court's property, my lord, that I'm trying to save.
We'll find out.
Please, my lord, please.
But as we said that it is not a touch and go solution.
Please, sir.
We have records from 1932, my lord. That's
I am aware of the difficulties which we are facing.
Seal number 12. So Manu Prabha.
Your lordship had heard, my lord, this matter for a short while, the last occasion.
My lord,
Lord, the matter pertains to my lord, a statute which seeks to violate orders of the Honorable Supreme Court and this Honorable Court with respect to removal of illegal religious structures. Lordship may kindly.
my lord, I have not obeyed my lord's order.
I reply
Denied.
not filed.
My lord,
You should not leave the
my
court.
lord, yes, I took time, my lord.
Should not leave the court with an impression that you are avoiding filing of.
No, my lord, I apologize.
12.7, my lord, that statement of objection filed, my lord.
What is 12.7? Same.
Yes.
And also, I filed impeding application, my lord. INM.
They have filed and they have admitted that there is an.
But this, serial number 12 is the substantive petition.
Yes,
Please,
my lord.
lords. 12 is the one challenging the validity of the statute.
What is 12.7?
May not may please to peruse order sheet dated daily order 12/8/2021. 12/8/2021.
91.
In that para number 2, 12/8/2021.
Petition is of 23. This petition is of 23.
No, my lordship, coordinate bench of my
Early.
lordship has reiterated. This petition is of 2019.
Like 17, if you are right, then petition of 17.
Okay, 27551.
19.
19.
12.5.
In that, para number,
One after one other.
yes,
You just go give the, which is that your matter? 12.7. Give 12.1 also. It is oldest. 12.1, 12.7 and 12.5, all.
this gives a background of this, complete background of this case in relation to the Apex Code directions.
One ತಿಳಿವಿಲ್ಲ ಸರ್ ನೋಡಿ one ತಿಳಿವಿಲ್ಲ ನೋಡಿ.
There was a direction that it should have been filed on number 25/2.
Flag again. Here.
ನಂದಿ ಕೂಡ
Here. ಇದು ಹಂಗೆ ಹೇಳಿ ಸರ್.
12/8/2021. I am referring, my lordship, daily order dated 12/8/2021. In para number 2,
First matter. 12.1.
Order sheet.
order sheet.
No, he's talking about.
You can finish it in 2 weeks.
So here in first petition, the prayer is to take action for construction of remaining lane road as per the sanction plan by removing the unauthorized structure named as Bara Imam Makan Dargah. What is 19.5? Let us see.
Submit.
My lord is,
This is in the city area.
no, not only in city area,
City area or state entire?
entire state,
Entire state, my lord.
entire state.
1893 is illegal structure constructed in the public properties. It means city area only.
No, in my
We are referring to your order only, 12/8/21.
12/8/21, para number 2, this suo motu writ petition has been initiated on 27 June 2019.
First paragraph deals with 18, refers to 1893 religious structures.
Yes,
They are in the, within the vicinity, within the territorial limit of the Bangalore.
Bangalore. But whereas subsequent petitions which are connected, para number 2 may please be seen. This is based upon the basis of the orders of the Apex Court passed in the SLP number 8519 of 2006. The orders of the Apex Court have been passed right from 29 September 2009, way back on 16th February 2010, the Apex Court has reiterated its earlier order directing that all the illegal religious structures constructed after the 29 September 2009 shall not be tolerated. This is a group of, so every time the government is and local authorities are taking time. Now, what is the use of the Apex Court direction? That is the reason Apex Court directed the Sanbu Court to initiate suo motu PL. Further, the suo motu litigation was initiated on the basis of the orders of the Apex Court at the Annexer B, which specifically direct this court to monitor the implementation of the said orders. I am reading 12/8/2021. Thus, 277 illegal religious structures which have been constructed after the 29th September 2009 on the public properties ought to have been demolished in the year 2010 itself.
13,275.
I'm sorry, I'm assisting because it's a
Now, what made you to file this petition?
Lord, my respectful submission is 12.4 was coming before this honorable court, and this honorable court was monitoring the implementation of the decision of the honorable Supreme Court, at which time the state legislature passes an enactment which says all illegal structures must be protected. Basically, my lords, preventing further progress of this petition, that is at 12.4, and other connected petitions where similar grievances appear to have been made out.
So legislature interjecting.
Apex Court judgment.
The last 1.5 years, they have not filed a counter. Your Lordship, my lord, today at least consider staying that enactment.
My lord.
1.5
my
years.
lord, I apologize, my lord. My lord, there has been.
Legislation cannot be done, it can be
Lord,
struck down.
in exceptional circumstances, your Lordship may exercise that jurisdiction. 1.5 years, they have not filed a counter. 1.5 years, my lords, 12.4 could not be given effect to.
When you are going to?
My lord, 2 weeks, my lord, I'll file it, my lord.
My lord, this matter is coming up after
My
matter
lord,
of 2 years.
I apologize, yes.
2
I made
years.
a mistake, my lord, I apologize.
It's not our
2
fault.
weeks.
It's a High Court is initiating suo motu PL and it is not coming to the board for a period of 2 years. Then what is the use of the purpose of PL?
Now it is on board.
My lord, that is the reason. That is the reason we are opposing the adjournment. Some action.
My lord, at the beginning itself, I was honest with my lord by saying that I have disobeyed my lord's order. 2 weeks, my lord.
We'll grant time, but in the beginning only we said that the court should not be left with an impression that you are avoiding filing.
No, my lord. My lord, there has been some miscommunication in the office. My lord, I apologize for that. My lord, 2 weeks and I will file it, my lord.
1235 of 2023 and allied petition. Along with the connected petitions which are as old as filed in the year 2019, 17 and 2019. Come on. The prayer in this petition is to is in respect of the constitutional validity of the Karnataka religious structures protection, Decatur Act 2021. First of looking to the importance of the subject matter and the public interest involved, by order dated 29/1/25, asked in writ petition number 12358 of 2023, the state was directed to file reply paragraph. Today, when the aforesaid petition along with the group of petitions come up for consideration, the reply is not filed in the petition of 2023. First of learned Additional government education with the deal over for praise for time for 2 weeks, within which it was submitted that the reply will be filed. Full stop. In the facts and circumstances, no time can be granted to file reply except up to 14th, up to 17th March, the petition shall be listed on.
Obliged.
Submission, my lord.
May I make
My lord.
small
Submission,
submission?
my lord. So for 12.3 is concerned, my lord, impeding application is pending, my lord, since from 3 years, my lord.
Implementing
Still
application.
pending, my lord. Impeding application is pending, my lord.
From 2021, my implementing applications are
Pending,
kept
my lord. Still
pending.
pending.
Who are you? You can submit. We'll hear you.
Yes.
We'll hear.
My lords.
In respect of the impeding applicants, there are over 10 impeding applicants. They have brought to the knowledge of this court some illegal structures. This court has been consistently directing the DC to give a reply to that, whether the illegal structures are.
Till today-
Not be giving the reply. DC may be directed to give reply.
So it appears that the all other petitions are for laying or completion of road, which is not being done because of some religious structure standing on the public space.
Yes.
Yes, my lord.
Petition of 2023 filed by this council is for challenging the constitutional validity of the very act.
Please.
Correct?
But-
In
but-
no other prayer, this prayer is, in no other petition.
No.
So this reply will be necessary.
My lords, in 12.3 and 12.2, our name may be removed, your lordship, since we're not in the panel. Our name has been showed as R2. Our name may be removed, your lordship.
12.2, my lord, if I may make one submission.
You file
The fourth
not
response.
to the registry for removal of law.
12.2 perhaps may not survive because the BBMP has filed now an affidavit, my lord. Whatever is the construction which is post 2019, my lord, they have removed it. That's their.
No.
Incorrect, my lord, the pendency of the writ petition, my lord, additional construction has been made by the trust, fourth respondent. My lord, I will brought to the notice of the court also.
But my lord, the honorable court has already ordered that his name should be removed as petitioner because he was an ex-trustee of the temple. Therefore, my lord, the order, my lord, has been passed saying removing him as petitioner. And my lord, BBMP has filed a report, my lord, stating that the encroachment pursuant to 2009, my lord, has been removed. So that's.
Has been removed. Additional objections filed by the BBMP, my lord. The copy.
Can you give the list of the religious structures?
My lord, I'll make an attempt, my lord, because there may be many.
Religious or semi-religious?
My lord, I'll make an attempt. How many I can, we'll see.
See, there may be two types of illegal structures. One on public property.
Yes.
The second one illegally constructed on a private property. So you bifurcate that and give also.
That list will be needing.
My lord, I'll try to get it.
So that the order may not operate
Because
in a
some-
wrong direction, whatever order is passed.
Yes, yeah.
Of the temples are constructed within the park also. Public park.
That the
See,
BBMP will have
the irony is, people tend to go there more than the older temples located in the same vicinity.
But in our case, blood, it's 40 years earlier, blood, and whatever is
Then
not
our
there, some
circle is
portion
an
of the
example.
chariot which was there, that blood they removed it. It's all not only of the so much petition not arises out of the Supreme Court order said after 2009, whatever has been constructed, not that is. So only post 2009, not is the question which arises. Pre 2009, not.
I think post 2009 are only on private.
Lord, in
Not Supreme Court itself observed
12.4,
not pre 2009 can be regularized by the state, not on a case to case basis.
no,
not for
Lord,
examining.
that may not be open anymore because by order dated 30th of October 2019, in serial number 12.4, this honorable court has passed a specific direction saying all structures prior to September 2009 which are illegal can be relocated, not legalized. So structures post September 2009 must be demolished.
Supreme Court is.
Supreme Court not
Not-
says regularized or relocated
This honorable
on a
court,
case to case.
at page 85 of my petition, this honorable court's order in the suo motu PIL.
That last time you showed.
Please, my lords. Therefore, even if it is 40 years old, if it is illegal, the only remedy is relocation.
That cannot be.
Cannot
correct,
be
my lord.
retained.
Supreme Court is very clearly says.
No, no, my lord. This honorable court has already taken a view that order has attained finality.
This,
That is by way of an interim observation, my lord, that cannot be said as having attained.
775, same which is.
Please, my lords. In that, the order dated 30th of October 2019.
Yes, 30th October,
Please, my lords. 30/10/2019.
page.
Lords, in my petition, it is at page 85, the relevant portion.
Is it
That is
30th
in
October?
12358.
25th October.
30th October, my lords.
30, yes, 30th, yes, it is. 30th.
The relevant portion, my lords, is at page 85.
Yes.
About 12 lines from top, my lords.
Noted earlier, the completion of documents while the state indicates state was unaware of the cutoff date of 29 sub. Exercise undertaken by the deputy commissioner. Correct. So, madam, file brief.
Yes, my lord, I will.
Please.
2:30 on 18.
Grateful.
Obliged.
Shall be listed, the petition shall be listed at 2:30 on 18th of March.
Our name may be removed, your lordship.
18, 17, file the statement, 18 per year.
Great.
Still number 13. Stellam Chidanandaya.
No, not that, you just move for time to me.
19 November 2024. Running page 14 in page 14.
Straight to your move, ma'am.
After para 7, page 14, para 7, after para 7. At this stage, Advocate General requested for considering the plea engaged in the blacklisting in court of quarrying operation as per order dated 5/3/2012. This honorable court has granted 4 months time to complete the exercise, which time would be insufficient in view of the nature of the investigation and the exercise to be carried out. The request of the learned Advocate General was received. The Dam Safety Committee is granted further time of 6 months to undertake and complete the necessary exercise and submit the report. This petition shall be listed on 28. After this, they had to file a report. The initial petition was to seek under section 959 conversion of the land development, and there was a clause included. So this honorable court converted this writ petition to a form of PIL, and an amicus curiae was appointed before this honorable court. And initial order was in 8/1/2023, your lordships.
My lord, 6 months time has been granted to 6 months time has been granted to complete the study and submit the report, my lord. This is order dated November 24. We are well within the time, my lord. The study has commenced, my lord. That is my instruction. The process has commenced. So we'll be updating the court about the status, my lord, because it may be called after some time, my lord.
It may be adjourned.
Please, my lord, because the time granted is 6 months from November, my lord, to undertake the exercise and submit a report.
For knowing the status, it is posted in between.
Yes,
Please, my lord, the status, my lord, I can submit a status report, my lord, in December meeting.
The directions in the order dated 19/11/24, whereby the Dam Safety Committee was required to undertake the exercise, necessary exercise, and submit a report within 6 months from Today, when the petitions comes up for consideration, learned additional government, Mr. Hari stated that the process is already on.
I can
And the
submit a
report-
status
and the
report also.
Status report will be submitted in due course.
Please.
Send over to. The petitions shall be next listed on 23rd April.
Very well. For submission of the status report, my lord.
Lordship, earlier, that was November, 6 months get over, your lordship.
November,
November, 6 months, sorry,
No, no, no.
6 months will get over, your lordship.
And it will,
April, therefore 23rd April.
apprise the court.
A week,
Gets over May.
My lord, the 6 months expires in 19th of May, my lord.
So after that,
Please, my lord, this will be,
after vacation,
please.
the 6-month period granted by the court would expire in the month of May. In that view, the petitions will be listed on 5th of June.
Grateful.
meanwhile, they can produce a report in between, your lordships, because it's an order of 18/1/2024, 2023, your lordships, 2 years. The writ
They will,
petition
if it
pending
is
in
available,
consideration.
then they will file.
Please, whatever is the status.
So green bench matters, seal number 14. Mr. Mahendra SS.
Yeah, for the petitioner, this pertains to the batch of matters where.
Hmm. 7.5. Oh, last order कहाँ गया? Last order is properly passed.
Page number
Stated
3.
by learned advocate Mr. S.S. Mahendra for the petitioner and could not be disputed by learned additional government advocate Srimati Nilofar Akbar, who appears on use of copy of the petition in advance, that the present petition is similar in facts and identical in prayers to writ petition number 32357 of 2024. As well as writ petition number 30419 of 2024. In which the orders were passed on 10th January 2025 and 13th November 2024 respectively. Full stop. In view of the statement that the present petition is similar, is based on the similar set of facts and the issues involved are also similar, there shall be notice in this petition. Returnable on
2 weeks.
Returnable
The
on
batch matters are posted on 28/3.
28/3.
Okay.
Then this paragraph to be before the toward the demand before the very concern on or before the next date deposit. Wait, Karnataka, on or before the next.
Published.
Shubham.
My lords, I appear for the petitioner firm, my lords. My lords, the lease and license of quarrying mining was granted to me on 24/10/2024 at Annexure P, page number 123, my lords. My lords, at page number 123, if my lords may see clause number 3, there, my lords, along with the petitioner firm's name, there are 3 partners' name mentioned, my lords. There, my lords, 2 partners are retired partners. The name Janet, Preeti and Florence Anuradha are retired partners. However, the existing partners are K.R. Satish, Rajesh and J.M. Richard. That is forthcoming in the certified acknowledgement that has been given by the district registrar firm at Annexure N, page 111, my lords. I have given a representation to the department, the respondents herein. Till date, they have not taken any action with respect to that where my names has to be reflected because it's still reflecting the retired partners' names. And I'm unable to.
When the deed was executed, the partners were in existence.
No, my lords.
Then why?
Subsequently, I've been made the partners and I have given the representation also to the respondent saying that the partners have been retired. New partners have come in.
So it will require, we don't know as per press deed will require.
My lord, this has to be looked into, my lord. This requires a little bit of consideration because there's confusion in the way it is narrated. My lord may grant me some time, my lord. I'll take notice and then
Malaj,
I'll apply.
until then interim stay with respect to transferring Malaj, yakandre we are new partners Malaj, our transfer madidre ಆಮೇಲೆ ನನಗೆ I will not be able to, I am the new partners, I've invested in this firm and the old partners are making an attempt to transfer this lease until next date stay may be given.
They have not been made as parties.
Malaj, my representation is with only with the respondents because I've given representation to them. Kindly, my lords, page 111, the district register of firms also reflects my name as the current partners. Page 111, annexure N.
Where is your representation? Q.
My lords, page 152, annexure Q, my lords.
Where is the mining lease copy?
My lords, mining lease is at page 123, annexure P.
What is your name? Rajesh.
My lords, Rajesh and K.R. Satish are the existing partners along with J.M. Richard.
Rajesh and Satish
Please, my lords.
are existing.
Yes, my lords.
Now,
But at page 123 in the lease deed, it reflects the name of J.M. Richard, Florence Anuradha, and Janet Preeti, who are the retired partners.
we do not know under what circumstances it is.
My lord, they were the power of attorney holders of these people, my lord.
My lords,
That is the reason
please,
why
my lord.
I said,
This can't be gone into detail.
My lords, kindly look at page number 111, my lords.
Here these persons were. Their names are.
It appears to be instance dispute intersect.
yes,
Please, my lords.
power of attorney holders are now claiming to be the lessees.
My lords, power of attorney is the wrong submission, my lords. Kindly look at 111, my
It is
lords.
your
Register of firms has made me as partners. In fact, this Honorable High Court has also passed in a order at my lords, at page 107, where it says that my partnership deed has to be registered. And I'm now the partner of the firm.
Who is this J.M. Richard?
My lords, J.M. Richard is the continuing partner.
Srimati Janet Preeti.
They are the retired partners, my lords. My lords may look at 111, my lords may have
Florence
clarity. my lords.
Anuradha, Robert Sampson, Saraswati Puram, Nandini layout post. So we don't know under what circumstances their name appears in this co-release.
My lords?
We do not know how their name appears in the co-release.
My lords, because at the
You are not partner at that time.
I was not partner at that time, my lords. As on 12/12/2024, that is on December. If my lords may peruse 111.
There must be some understanding between the partners intersect. We do not know what is that.
Please, my lords, I do agree. But now, my lords, since the existing partners' names are reflecting, he's taking advantage, the continuing partner. I have invested.
So it is intersect dispute between you.
The respondents have to decide on that, my lords. Until then, stay may be granted because if they accept the transfer, then my rights over the partnership firm is, my lords, may kindly grant stay until they take steps on it because I've given representation also. I've given in the month of January and till date, they have not taken it.
Jurisdiction of this court under Article 226 of the Constitution is invoked in this petition. Wherein the prayer is made to direct the respondent director, Department of Mines, Bengaluru, to consider the representation dated 3/1/25 submitted by the petitioner firm. The next prayer is to direct the respondent to issue corrigendum with respect to the quarrying lease oblique license deed dated 24/10/24, and thereby to amend therein the names of the partners of the petitioner firm. Petitioner 6, his name to be entered as partner. Petitioner Rajesh Bhatt H6, his name to be entered as partner, as existing partner. The third prayer is to direct the respondent to issue corrigendum in respect of the said quarrying lease to rectify the quarrying lease number from QL number 396 to QL number 397 in the deed of license oblique lease dated 24, aforesaid deed of license oblique lease. The case of the petitioner is that he happens to be a partner of the partnership firm Messrs. Angel Granites, which is a registered partnership firm. According to the petitioner, he became partner of the firm on 12/12/2024. It is the case that in the quarrying lease deed dated 24 October 24, I'm to get copy of which figures at page 123 to 126 to 120, whatever it is. 124, 120, 143. Take it over. Comma, the name of which page you read? 124. 120. The name of the old partners who are Sri J.M. Richard, Srimati Janet J.A.N.N.E.T. Rithi, Srimati Florence Anuradha have been mentioned. It is the case that these partners are now retired. Who is the partner in addition to you?
Lords,
Who are the partners today?
who have retired, my lords.
Who are the existing partners?
Existing partners, my lords, is K.R. Satish, Rajesh Bhatt, and J.M. Richard. J.M. Richard is the continuing partner.
It was stated that out of the above partners, J.M. Richard is a continuing partner and one Satish and the petitioner here in Rajesh are the new partners added. Full stop. It is in this paragraph. It is in this light. It is in this, it is with this premise of contention that the prayer is made to amend to consider representation and to amend the lease deed by issuing corrigendum. Full stop. Not only that, the petition involves questions of fact to be gone into, comma. Prima facie, it appears to be a dispute inter se among the partners. Full stop. While the petitioner seeks the prayer as above and further seeks interim order against the individual partners, contending that the quarry might be disposed of behind the back of the petitioner, comma, the petitioner has not even joined the partners against whom the grievance for grievance as above is raised. Full stop. The total compass of the controversy and the nature thereof will not permit the court to invoke its extraordinary jurisdiction, writ jurisdiction to grant relief. Full stop. The kind and nature of the petitioner and the relief prayed for are not maintainable in a writ jurisdiction and Article 2 of the Contempt. The petition is dismissed on the aforesaid ground only, without expressing anything on the case of the petitioner, full stop. This dismissal will not preclude the petitioner from pursuing his representation before the authorities.
Obliged.
16, 17 are adjourned. Seal number 18.
16, 17 is adjourned.
Number 18. Sumana Nagana.
But here we are to.
Lord, the petitioners, Lord appellants before my lords are distribution licensees. And my lord, the respondent 1 and 2, my lord, they are generating companies. Lord, these respondents, my lord, had some contracts with Andhra Discoms, Andhra distribution companies for supplying power. Lord, Andhra Discoms did not want that power, and they were told that please back down, don't give me the power which you have contracted for. Therefore, my lord, that same power which they had contracted with Andhra Discom, they supplied to Karnataka, my lord, because there was an order passed by the government for compulsorily acquiring power because of the shortage that we were facing. Now, my lord, the controversy, my lord, which arose is Andhra gave them some compensation because they were not taking power to an extent of, my lord, 8 crores, 67 lakhs. They received, my lord, compensation for not supplying power, taking power by Andhra Discoms. The Karnataka Regulatory Commission, my lord, considered what should be the price that I pay to these generating companies for the power supplied by them in that period. And while considering that, they said that 20% of the value, my lord, has to be, my lord, deducted, and they fixed a particular price by saying that you have, because somebody else did not take that power and you partially got compensated for that, and you have paid, you have supplied that power to us, it is to be considered as an infirm power, and they fixed a rate. Lord, that was the order, my lord, which was challenged before the learned single judge.
Where is that order of the Regulatory Commission?
Lord, Regulatory Commission's order, my lord.
Page 169. No.
Lord, it begins, my lord, at page 79. 79. So elaborate order, my lord, operative portion is at page 133. This 20%, my lord would find at paragraph 2 of the operative portion of the order. Lord, what has happened? Lord, while deciding, my lord, the writ petition, of course, my lord, we raised an issue of alternate remedy because this is an appealable order. Other than that, my lord, the learned
order of the commission is appealable.
Appealable, my lord, to the appellate authority under section 111. That question was raised. To that, in the impugned order, my lord, the answer given is that if there is a lack of jurisdiction, then it is something which could be raised. But so far as jurisdiction is concerned, my lord, under section 11(2), KERC, my lord, the commission which has passed the order, it is the only authority which can fix the compensation, my lord, which has been done. Therefore, there is no question of, my lord,
Give the act.
14, page number 14.
Is compensation towards some interruption in the.
Lord, what happens, my lord, is if there is dire Lord, need of power and there is shortage, government has the power under section 11 to compulsorily ask the generating companies to supply power only to the state entities. Such an order is passed. My lord, under 11, that order, my lord, my lords would find at page 170. Lord, after all the preamble, my lord, the actual order is at page 173.
Now, did you pass an order under section 11?
Government passes an order.
Government, did it pass an order
Yes,
under
yes,
section
that is
11?
that is under my lord, that is a 170 annexure E, page 170 is the
Pursuant
order.
to which you, power was supplied to you.
Yes, my lord, some power, my lord, which they were selling to Andhra, which Andhra did not want, that, my lord, landed up in my grid, for which, my lord, I have to pay. Question, my lord, is what is the
Was there
amount?
a contract between you and them?
My lord, there was no contract for the power that they supplied, but the learned single judge, my lord, relies on annexure G.
Asking a few questions.
No, no.
Was there a
No.
contract?
No,
At what rate they were required to supply the
No.
power between?
No.
So,
it is governed
But-
by this order.
by virtue of the order of KRC, the rate got to
Rate is
be
fixed.
fixed. The rate is
fixed.
fixed. It took into consideration the existing rate that was being paid by you to similarly situated persons.
And also the
And
category of power.
also the question, and also the fact that they have been partially compensated by Andhra Bescoms while determining
Commission
the
says
power.
you may not directly get benefit of that, but because this is considered as infirm power, because they did not take it, you gave it to us.
Does the statute lays down the guidelines based on which KRC has to determine the rate?
Lord,
And does it provide for it? See, because what happens, in law, you're all companies today, a separate person in the eye of law. You're a separate company, Andhra Bescoms are separate companies. Now, they did not, there was some breach of agreement over there. They did not want the power to be supplied, for which they have compensated.
Yes.
For you to take benefit of it, there has to be some provision in law.
Lord, section
Unless you show it, the question of that.
11.2, Lord, kindly have a look at Lord, section 11.2. This is the power of the commission, Lord, to determine the adverse financial impact, Lord. What is being, Lord, this is not a situation where they have to make a super profit. I am in a dire situation of, Lord, shortage. They are supplying power, my lord. There are judgments, my lord, of this honorable court in GMRs, many other judgments, my lord, which considered what is the nature of exercise under 11. So, commission is supposed to fix whatever is fair as the compensation for, in this situation, where there is acquisition of power, what should be the compensation? That power is vested in the commission under 11.2. That exercise has been done. Now, my lord, what has happened, my lord, is the learned single judge proceeds on the assumption that there is a power purchase agreement between the parties. Lord, that in that context, Lord, there is reference to annexure G. And the entire order, Lord, says that this concept of firm and infirm power is not existing in that PPA. And therefore, how could you import that into the transaction between the parties? And, my lord, the learned single judge, my lord, has considered if there is a bargain of parties, how, my lord, that has to be, my lord, given effect to, etc., my lord, that's the refrain. But, my lord, the fact remains that if you kindly see, my lord, the section 11 order at page 174, clause C specifically excluded all generators who actually had a power purchase agreement with the discoms. So this order operated only in a situation where there was no PPA with the discoms, and these generators who were supplying to others, either in open access, my lord, or to outside the states, etc. 174, my lord, C. On the contrary, if annexure G, my lord, applies, then, my lord, kindly see, my lord, page 189. Clause 4.1. This fixed a rate of 3.47. This is pertaining to energy which is not supplied, which is not part of the present dispute. So if annexure G had to be applied, what was payable was 3.47, contrary to the tentative fixation of 5.08.
This will be required to be heard.
That's, so far as alternate remedy is concerned, I would only submit.
No, we'll hear that length.
Your lordships can fix a date for hearing. I have no objections on that. But my lords, the issue is not what my learned friend is projecting. Section 12 is a general tariff order. My lords, the issue arose only on this. PCKL, that's generate, my lords, the consumption company suddenly raises a demand saying, lords, I had a medium access agreement with Andhra and Telangana for supply of power there. Those agreements have several clauses. In case there is a shortfall by them in procuring the power, lords, I will be compensated. If there is a shortfall in supply, I'll have to give them damages. Now that there was a shortfall in procuring by those DESCOMs. There is a dispute there, not entire money is not paid at all. Using advantage of that, during the pendency of that, the government passed an order mandating us to supply power to DESCOMs here. That's under section 12. Tariff is fixed by KRC across board. We are not into that tariff at all. My lords, what the BESCOMs and Power Corporation does is, you are entitled for compensation or damages from DESCOMs of Andhra and Telangana. So since you have supplied it here, the power, because there was a shortfall there and you supplied it to us here, we will not pay you that amount. We will cut the compensation which you will be receiving from them. Now, when I go to KERC, it's an adjudicatory mechanism. Because it's my petition before the KERC. KERC categorically gives a finding. They raised a question of unjust enrichment by us. KERC says it is not a case of enrichment at all. It should have closed at that stage. It proceeds further and says, all, my lords, it holds in my favor till then. Then, my lords, KERC takes it upon itself to say, infirm power concept. And it says, they have not pleaded, but I will go into it. It's a case of an infirm power. So you will be entitled for a lesser tariff than what you're. That was not even the case before KERC. That is the issue. So far as alternate remedy, my lords, they had filed a writ appeal. Initially, we had a benefit of an interim order. They filed a writ appeal. In the writ appeal also, alternate remedy was gone into, but left at that. Matter was taken up, my lords, after years. Today to say that alternate remedy may not arise, because that issue should have been taken up at the appeal itself when they challenged the interim order. And that was raised. And this honorable court did not get into that aspect at all. Now, my lords, whether I am entitled for compensation there, how will they get that benefit, my lords? In case tomorrow, my lords, in any event, if I have to pay DISCOMs of Telangana and Andhra, will the DISCOMs of Karnataka pay me? That will never arise. That's the only issue. And this infirm power is a concept which is not known. Infirm.
Is it an independent issue or not?
My lords, infirm power was not even an issue. The order did not say. KERC takes it upon itself. Lords, when you are adjudicating, you can't take it upon yourself to say, I will consider this as an infirm power. And KERC says, they have not pleaded, but I am considering it. The only definition where we can find what infirm power is under the Central Electricity Regulations, which says infirm power means power supplied before commercial operations. How to say off-peak power because they took less, you have supplied, all this was not an issue before KERC at all. Once it held that it is not a case of unjust enrichment, that issue should have got closed at that stage. That was our minimum. That was the prayer. And that's what KERC order says. If your lordship kindly come to page 39 of the KERC order.
We'll hear on second.
Your lordship may hear this. I have no objections on that.
In the meanwhile, my lord, I seek, my lord,
No precipitate.
yes.
Lord, they have to pay me for the power which they have consumed. I am not saying for the arrears.
We have paid.
Whatever now they have consumed the power. Now they say we will not even pay you anything. That can't be the case.
We have paid, my lord.
No, that was the issue.
He wants us to pay the difference.
No, that was not the issue.
Views are quantified.
My lord, it was quantified. Now what they consume, my lord, they can't hold it.
My lord, I have paid. I've only recovered, my lord, 4.4 crores, my lord, from which, my lord, is directed to be undone now.
Not undone, my lord. We have given the chart also. Now, if somebody can't say, I will not pay, I will consume.
There is a letter, my lord, which clearly points out what was the, my lord, quantum of money, my lord, which I have withheld from the, what was payable. It is 4.4 crores.
What was challenged before the demand notice, your lordship may kindly see, annexure C. They say they withhold the amount. They can't do that, my lords. And this power is supplied in 2016 or so. It's now 8 years.
Lord, page 152,
Impugned order is at annexure B and C.
page 152, my lord. I have paid at that rate.
2nd April, if contempt is filed, we'll see.
Not let there be an order to say no precipitate action.
I'll have to come before my
Otherwise,
lords only.
Lord, so far as that amount quantification is concerned, my lord, clearly one page 152, I have said what I have done.
Lords, we have disputed that. Please see the demand. My learned friend is pointing out to certain documents.
No, no,
We have,
I
we have
will
also
show.
filed the charge before the learned single judge.
Sir, I will, let me show what is my communication. Lord, the net effect is this.
See, they might have received the money or they may yet to receive the money from Andhra Best Corps.
Lord, the commission has not gone into that compensation
No.
element.
No, I'm telling you.
Yes.
Now, based on that, how can you say in law that you will pay him lesser than what you pay to similarly situated person?
Because it's a quantification of adverse financial impact. What was, Lord, electricity is now considered as goods.
Correct.
Supreme Court judgment says, my lord, it is goods. My lord, a goods is worth 100 rupees. He was supposed to sell it, my lord, to person A. He has refused. My lord, like mitigation of losses, my lord, that goods which is worth 100, my lord, is being given to me. Now there is an agency, my lord, which is supposed to determine what is the adverse financial impact. In doing that exercise, my lord, the commission, which is the only authority under 11.2, considers the nature of the power and says that because it is infirm, my lord, I am giving a deduction to that and I am fixing a rate. That computation, my lord, page 135, first appellant, my lord, has given all the computation as to what is that 20% translates to, and that quantification has been done. Now, my lord, learned single judge, if you kindly, my lord, for a minute see page 50, says that there is a power purchase agreement. Paragraph 21. PPA between the parties are conspicuously silent on distinction between firm and infirm power. There is no such PPA. And the entire, my lord, consideration after this is on the premise that there is a contract between parties and that bargain is to be given effect to. That does not say firm or infirm.
Let us for a minute presume that there is no power purchase agreement between you and.
Lord, if my lord, I apply that power purchase agreement, as I pointed out, my lord, page 220, what I am entitled, my lord, liable to pay to him is 3.47 and not what is fixed under the government order. I am ready to do that.
My learned friend is going beyond. Lords, it is an order mandating compulsory supply of power for which tariff is fixed by KERC.
They did not supply, my lord, pursuant to that order. When only when, my lord, somebody else said, I don't need it, they have, my lord, left that power in my grid.
Very strange argument, my lords. When the state says you compulsorily.
See, you required it.
I supply it to them.
My lord, I have said,
It is like,
Lord, I have taken that power, my lord, I have paid. Question, my lord, is what should be the rate at which I take it.
And please see the impugned
That is,
communication which came to
that's
me.
the adjudication.
See, you are a different person in the eye of law. Andhra Bescoms are a different
Correct, my
person.
lord. That is, I'm not saying, my lord, I'm not identifying myself with Andhra. They had a contract
Then
with them.
How are you entitled to deduct what Andhra pays?
That was not allowed to be deducted. Commission, my lord, has done an independent exercise of,
Whether the commission could
Lord,
have done it.
exercise of determining what the cost of that power should be, precisely because there is no PPA. But the learned single judge proceeds that there was a PPA. If this is the PPA to be applied,
But
there is a rate.
You just now submitted that
There is no PPA.
amount paid to him by Andhra Bescoms has to be factored in while determining.
No, that was my case. That was my case before the commission. Commission says, don't go by that, but I will do an independent
Whether
determination.
commission could have
That
done
is-
under 86.
That is the, my lord, power that they have under 11. Because it, as we all agree, my lord, it was 11 supply,
Oh, no.
supply under section 11 order. Then determination has to happen. Even the government order says, even for power that is supplied, it is subject to.
We'll hear on second, 10.26.
Please,
If they file contempt, we'll see.
very well.
10.26.
Lord, at least, my lord, let them give an undertaking that they will not take any other coercive step. Lord, may I request, my lord, that let there be an order not to precipitate, because, my lord,
Let
unnecessarily,
them
my lord,
deposit the money with interest, my lords. They have utilized it from 2016. They would have
Quantification
passed
is
on
yet to
the
happen.
same thing to the consumers.
No, we'll see on second
Please,
if it is
Manoj.
not possible. What to do?
Still number 19, the state appeal.
Delay,
my lord, I'll take out notice.
notice returnable on 13th, 16th April.
Number 20, to Mohammed Asha.
Same,
Appear for the appellant's counsel.
delay,
28 days is notice
39
period.
days. Notice, same,
Number 21,
Public.
same, 16, notice.
My lords, appear for the appellant, my lord. There are 3 other writ appeals connected, my lords. Lordships may have all the 4 on a date, my lord.
Which one?
Writ appeal number 1542 of 24.
When they,
Appeal number 21, my lords.
when they are going to be listed.
Fresh matters, my lords. We have complied with all the office objections. All the 4 may be.
My lord, appear for the caveat or.
Following matters along with the above matter.
Those writ appeals.
Stated to be
I'll serve, I'll
connected,
serve.
or may be listed on 16th April, provided all the office objections are removed. 1, 2, 3, give the number.
I've given the numbers.
They may also serve copies on me, my lord.
I'll serve, my lords. I'll serve.
So,
Much obliged.
still number 22,
Please, Your Lord.
Yogin Bachar.
Before the learned single judge, the petitioner had sought for a prayer, which your lordship will find on page 30. All that I am seeking for is consideration of the recommendations made by the authority, by the government. However, the learned single judge, in its impugned order at page 15, paragraph 4, holds that the gentleman who had recommended this has since been suspended, and consequently that recommendation is bad. I am instructed to submit that dismissal or action against him was not with respect to this issue, but some other issue in some other place. If it is considered, the entire issue gets over here.
you want extension?
No, I am seeking for extension. There is a recommendation. I want the government to consider it. If they say no, then the chapter is over, Your Lordship. But that recommendation was done by a person against whom some inquiries were conducted, and he has since been, I'm told, suspended or dismissed.
Subsequently suspend and dismiss.
Yeah, but that I made inquiries is not relating to this issue. It was for some other issue in some other place when he was posted.
Otherwise a competent authority to recommend.
He was a person in charge of the coastal area who recommended it.
even otherwise, this tender has been called in the matter. They were given liberty to participate in the tender. This is build, operate, maintain and transfer, my lord. That was an original agreement was.
So
on the-
tender is also already issued pursuant to.
Please, my lord, 2011 was the original agreement under which they were awarded the contract. That has come to an end. It was initially for a period of 5 years. Thereafter, my lord, for 3 months, about 2 to 3 times extensions were granted to them. And finally, my lord, the tender has been notified in 2019. They had sought for stay of the tender in the writ petition and requested for consideration of their representation to extend the time so that they operate. My lord, this has to, they don't have a matter of right to ask for it, my lord. It's a process of tender. So they have to apply, participate and participate in the tender and get the contract awarded.
Your Lordship, what I'm seeking for is, after the period,
We are removing the cost, but dismissing the appeal.
but then your Lordship may note, I can participate in the tender. I can,
That will observe that you can participate.
please.
Provided you are not blacklisted.
No, Your Honor. What is the issue involved is that I developed it and I expended a substantial amount of money. The period got over, they did not extend it, but I continued. They continued receiving the amounts. And after receiving the amounts for a period of 5 years post the conclusion, they suddenly wake up and initiate this.
On a single year said that you can participate in the last period, possible.
Para 6, my lord.
Possible is said.
Please.
That is my.
Para 7.
Para
here.
7, my lord. Page 17, para 7.
But only my submission here is, if the government were to consider my recommendation, Your Lordship, it would be that all other issues in law, if they reject it, then this procedure still will continue. But if they consider it, at least the satisfaction to the appellant that my prayer or whatever recommended was considered. It's the prerogative of the government to reject it also. All that I am saying.
So we'll say, noting your request that request to participate in tender is granted, provided you are not treated as blacklist.
That there is no order for blacklisting them
Then
here.
why should you?
Lordship,
Participate, my
all
lord.
that
There
I'm
is
seeking, Your Lordship, is consideration, Your Lordship.
Learned single judge has already reserved them liberty to participate.
Nahi hai. It is not there. Only liberty to issue fresh tender.
No, para 7 may kindly be seen.
Respondents are reserved liberty to claim losses. It's not
Please.
from me. I'm the appellant. Reserved liberty is not there.
No, they can be given liberty to participate, my lord. The state 2019 tender, my lord. This
ಅಷ್ಟೇ
is.
ಅದಲ್ಲಪ್ಪ.
If it is not called for, they can participate.
The prayer before learned single judge of the appellant original petitioner was to consider petitioner's apostrophe as letter dated 8/11/2013, whereby the request of the petitioner was to extend the lease/contract period for further period of 50 years. While not entertaining the
Stay ಇರ್ಲಿಲ್ಲ.
it was next period to certify the tender notification dated 25/1/2019, which was published by the.
Those tenders have never acted upon.
The daily newspaper dated on 27/1/19. Post of learned single judge, noticing the relevant aspect that the lease of the petition itself had expired since the same was for a period of 5 years. The question of seeking extension of lease for 50 years did not arise. While the petitioner relied on the letter of the Assistant Director, Government of Karnataka, Tourism Department, dated 8/11/13, which recommended for extension from a learned single judge has directed the principal secretary as to initiate the inquiry and submit a report as to how the recommendation could be, such a recommendation could be made when the lease period had expired. While dismissing the petition, paragraph, with cost of ₹1 lakh, comma, the respondents are directed to, respondent authorities are directed to issue fresh tender notification at the earliest and proceed thereafter in accordance with law. So respondents are also put at liberty to claim losses and losses by initiating appropriate proceedings. Full stop. On consideration of facts and the submissions made by both the advocates, comma, and submissions made by learned advocate Mr. So-and-so for the petitioner and learned additional government so-and-so, comma, the court does not find any infirmity in the order of learned single judge. However, imposition of cost of ₹1 lakh could be said to be harsh. Therefore, the cost part is removed, and the same is set. And the direction to pay the cost is set aside. Full stop. The appeal is dismissed. Full stop. Paragraph. At this stage, learned advocate for the petitioner appellant submitted that in the fresh tender which may be issued by the respondent authorities, comma, petitioner appellant may be permitted to be participated. It is observed that the petitioner may participate in such tender process which may be initially repressed in accordance with law. If the petition is not otherwise blacklisted.
No,
No, yeah.
I'm not blacklisted, but by mentioning it by.
Nothing on record to show that they have been blacklisted, my lord. There is liberty always for them to participate.
If he is qualified, your lord.
If they are qualified, they can participate, my lord. as
If
well.
qualified in accordance
Please, my
with
lord.
law.
Yeah, please. Please.
This is number 23, Mr. Naveen Jain.
Petition is for the
Delay of 32
23.
days.
serial number 23.
Delay of 32
So,
days.
Notice
Notice, sir.
returnable on 3rd April.
Right.
Number 24. Mr. Milind.
Yes, my lord, this writ appeal is in against the order passed by the learned single judge in WP number 5759 of 2024, directing the resolution professional or the liquidator to refund the amount what he has been forfeited for taking part in the auction and not fulfilling the, not signing the LOI and not taking the matter forward. There is a clear-cut understanding that if you do not take it forward after you have been selected as H1, the money will be forfeited. It has been signed by him, and this agreement was given to him much earlier than he could take part into that one. Your Honor, may the signed agreement or the proposed process memorandum commences from page number 276. The relevant paras are 6.3 and 4.13. He has signed this document, Mr. much earlier. 6.3 clearly says that failure to accept the LOI within the time period specified may result in the disqualification of the successful bidder along with the cancellation of the LOI and forfeiture of the earnest money deposited and participation bid amount. And in another places 4.13.
Now this decision referred to in paragraph 7 of the order.
Yes, my lord.
V.S. Palanivel.
Yes, my lord. The schedule 1 of the crossed.
Justice Parrivalas.
Sorry, my lord.
It is Justice Parrivalas has been recently delivered.
No, my lord. His lordship Justice
Refund
Kohli.
of the money, earnest money.
His lordship Justice
Refund of the
Kohli.
deposit.
His lordship Justice Hima Kohli, my lord.
So which rule will apply regarding?
No subject.
Mela, my attack of the
See, the definition of earnest money deposit.
Please, my lords.
Earnest money deposit is deposited to show the earnestness of the buyer.
Please, my lords.
Unless there is a term contrary to it, it will have to be forfeited. For forfeiture, you don't require an express term. That is the law laid down by the Supreme Court, some 1963 judgment or something. I'm not able to recollect. Need to look into it.
that is under section 74, Mela. Could not bring it today, that judgment. I have gone through it. Maybe next date I will bring it, Mela.
We're relying upon, my lords, schedule 1 of liquidation process regulations rule 33.
See, schedule 1 is silent with regard to EMD.
Yes.
Schedule 1 is silent with regard to forfeiture of EMD. It does not say that EMD cannot be forfeited.
It talks about EMD, my lords.
It talks about EMD, but it does not speak anything about forfeiture of EMD.
It does not, my lord. It does not
Ah,
provide
it
for
does not
forfeiture.
speak about forfeiture of EMD.
It does not, my lord. It does not.
When it is silent with regard to forfeiture of EMD, the concept of earnest money deposit as it has originated is that to show the earnestness, the bidder pays that earnest money deposit. And if the contract fails due to the fault of the bidder, then the earnest money is always forfeited.
May I make my submissions, my lord?
No, you just make that research. This is what Supreme
I'll
Court
go
has
through it.
suggested.
I'll go through it, my lords. I'll
Bring that judgment.
I have not brought it back today. Next date I will bring.
Next.
Yes.
May I make the submission, my lords? Now this 70 lakh rupees has been directed to be refunded by the learned single judge. Now, my lords, in the hands of the appellant, my lords, the appellant being a liquidator, my lords, the possibility of that amount getting paid off to the other creditors of the company is very high. Tomorrow, my lords, even if assuming for a moment that I do not know, as my lordship says that I may not be entitled to refund. But if I am able to convince my lords that I am entitled for a refund, the money should still be available with the appellant, my lord, for dispersal to me. Likelihood that he might disperse it off to the other creditors. May I request your lordships to direct him into either deposit it with the honorable court or in a fixed deposit, my lord, so that at least, my lords, the money is safe, my
Keep it
lords.
on 19th of 20th of March.
Publish, my lords.
Much better.
Still
There
number
are, my
25.
lords, I'm so sorry, my lords. I'm so sorry. My lord, another point, my lords, for consideration is that Schedule 1, my lords, provides for a 90-day period for the payment of money, my lords. Here in this present instance, my lord, the amount has been forfeited within a period of 2 days. Even assuming for a moment, my lords, if forfeiture is permissible under law, my lords, that fact that, my lords, it was done contrary to the timelines which is provided by the rules, my lord, will come into play. And
That's a different aspect.
And another point, my lords, is that
No, my lord.
in the
there was-
judgment of Palanivel, I'm so sorry, sir. So sorry. In the judgment of the Honorable Supreme Court in Palanivel's case, his lordship says that Schedule 1 has to be mandatorily followed. If, my lord, if the 1963 judgment and this judgment were to be read together, even though the EMD forfeiture is provided for, my lord, and can be read into the regulations, it has to be, timelines have to be followed, my lords. Within 2 days, forfeiture could not have been done. Here, within 2 days, forfeiture has been done, my lords. That also, my lord, is a point for consideration for your lordships. Therefore, my lord, if EMD, my lords, if that, my lord, is a ground, my lords, if I have a case, my lords, on that ground, lordship, my only apprehension, my lord, is that tomorrow, if I am able to convince my lord, the money should still be available. That's my only concern, my lord. Let it not be given to me. Let
I
it
will
not be given to me, my
That
lord.
they will,
I will submit, my lord.
on next.
Next date, okay, yes.
Oblige, my lords.
Much obliged.
Still number 25. Nayak NR.
I beg to appear for appellant, my lord. In this case, my lord, the appellant, he has allotted a site from KIDB, my lord. Then he has made an application before the Canara Bank. The loan has been sanctioned. And immediately he has made an application before fourth respondent, my lord, for grant of subsidy amount from the government, which is entitled by me, my lord, 1,55,000, 1 crore 55 lakhs, my lord. Now the same has been rejected only on the ground that I am not owner of property, my lord. But lease cum sale agreement, my lord, it is a 10 years period. And time has been granted to pay the installment. Industry shall be constructed within 3 years. Such being the case, my lord, the subsidy amount shall be released immediately after sanction of the loan, my lord. That is the law. Now only net worth has been considered as if I am not owner of the property, my lord. But as per the rules and regulation, my lord, 15 point has been given: sale deed, lease cum sale agreement, and other allotment letter. Allotment letter net worth has been mentioned, my lord, 2 crores 55 lakhs, my lord. That is worth of the property. But as per the government of Karnataka, it is concession has been given for scheduled caste and scheduled tribe people. 25% of the net amount, my lord, it was payable by us. That is the allotment letter is also issued annexer B, my lord, annexer C. So therefore, I am entitled for subsidy amount, but rejected as if I am not owner of the property, my lord. Now the learned judge, my lord, consider that you are not a owner, therefore you are not entitled. But however, you have paid the installment, you go and submit a application fresh. And whether they are
So
going
you are
to
supposed to
consider
submit
based
the
on this, my
document.
lord, because net worth has to be considered as per the immediately allotment, because I have started the industry by availing loan, my lord.
Yes, not annexed the impugned communication to the writ appeal, my lords.
Where is that?
Yes, not annexed. Not annexed. In my copy, it is not there.
What was
Learned-
the what is the communication?
Lords,
That is
some-
a page number, my lord.
What was that communication?
Communication is that the
Page number,
committee,
my lord, 163, my lord.
the committee constituted under the
103,
scheme
my lord.
scrutinized the all proposals of 127. They verified whoever is not ineligible, they have been listed out, and for what reason. In his case, my lords, he did not produce a document to prove his net worth, what he had claimed in the proposal, my lords. That is the communication. That's why learned single judge referred to it, and it says that there is no arbitrary approach by the committee. And you place all the material to satisfy your net worth according to the scheme, what is required, my lords. That is the learned single judge's order, my lords. He has not come before the authority to place on those records. He is claiming that land has been allotted according to the market value, this is so much. That cannot be taken into consideration because that learned held that land has not yet been registered in your name. Whatever the amount you have paid to the towards land cost is only 20 lakhs. That can be considered as net worth.
But eligibility is concerned, my lord, as per their rules only. Lease cum sale agreement is also 0.15. Sale deed is also 0.15. But that fact is not at all considered by the committee, my lord. Because now, my lord, within 3 years, I have to put up construction. 10-year lease period is there. If I am violated, my lord, I could not able to get subsidy amount. Loan sanction letter I have enclosed along with my application. It is under the scheme, my lord, Pradhan Mantri Yojana scheme, my lord. It was granted food processing unit. Food processing unit, it is cost about 3 crores, my lord.
Council, come to para 6 of the judgment.
Please, my lord.
You are only required to produce all the necessary details. If you produce the necessary details,
Yes, my lord, I have
the
produced, my
respondents
lord,
will
all
consider it in
I
accordance
have
with
produced.
law.
Now, my lord, observation made, I am not owner. That is the, my lord, again, the same thing is going to be happen. My
Nothing
learned
has
friend is
been
also-
concluded in the writ petition with regard to your rights.
Yes, my lord.
Admittedly, it's a lease cum sale agreement that has been executed in your favor by KIDB.
Yeah, yes, my lord, KIADB.
Yes, produce all the necessary particulars to the respondents. They will consider it in accordance with law. That's it.
The observation, my lord, kindly maybe look into para number 3, my lord.
It is not a finding given, sir.
Yes, my lord. Yeah, I am not.
It is the
owner.
contention
That is the,
recorded.
my lord. That is the point going to be considered, my lord, because the writ petition has been dismissed.
You
only on
provide them the
ground you are-
necessary documents. Writ petition is
And this
disposed of. It is
observation-
not dismissed.
If this observation, my lord, can set aside, my lord, I am ready
Learned
to place,
advocate,
my lord.
there is nothing. Only thing that we are hearing you for your satisfaction. Third learned advocate, Mr. Nayak NR for the appellant and learned.
Kumar MN CGSPC, man, for respondent 1, 2, 4 and 7.
Learned Kumar.
Kumar MN.
MN for respondent 1, Union of India, and this one 2, 3 and 4, the authorities of Union of India. Whereas learned.
Respondent number 5.
5, 6, 8.
Government advocate, Mr. Harish appeared for respondent 5, 6 and 7, 5 and 6.
This is KIDB, my lord.
5 and 6.
Please.
5 and 6. Full stop. The challenge in this appeal is
Months.
directed against
5 and 8.
judgment order of learned single judge dated 20th January 25, whereby learned single judge has disposed of the petition with certain observations. Full stop. The petitioner, the facts to be noticed from the record are inter-alia that the petitioner has been allotted industrial site number 743/1 of Harohalli, third phase industrial area by the Karnataka Industrial Areas Development Board into bracket KIADB bracket over. Full stop. What the petitioner wanted from respondent number 4 authority was the subsidy under the scheme called Pradhan Mantri Kisan Sampada Yojana. And wanted the site at subsidized rates.
One correction, it is not for subsidizing the site, my lords. It is a,
For
it is not subsidizing the site, my lords. It is subsidy being claimed for the project.
Project.
claim
Under-
subsidy, subsidy, full stop. The stand of the central government was inter-alia that the sale was not confirmed in favor of the petitioner, or that the competent authority had considered only payment of only about ₹20 lakhs at the end of the petitioner, having regard to the concession given by the KIADB for allotment of the site, and that the petitioner was not absolute owner of the property and was only a leaseholder. Therefore, whatever amount was paid by the petitioner to the KIADB was taken into consideration. Full stop. As against the above, the case of the petitioner was that he had paid 50 lakhs to KIADB and that the entire sale consideration was paid, which was, and it was further stated by the petitioner that he has ₹30 lakhs in the fixed deposit. Full stop. Having considered after considering the rival submissions and the facts of the case, learn a single judge dispose of the petition with these directions as found in paragraph 6, extracted in above. Bracketed portion. Full stop. Therefore, the petitioner is required to resubmit all the documents and satisfy the requirement of the scheme and showing his net worth under the scheme. Thereafter, the respondent is directed to proceed to consider the approved orders. Full stop. The order of learned single judge containing the above observations, permitting the petitioner to submit the documents and requiring the authority to pass the necessary orders in accordance with law on the basis of the documents which may be submitted, could be said to be eminently just, proper and legal. No interference is called for. The challenge is meritless. The appeal is dismissed. Public. Yes, next. So and so heard,
So Rajan,
heard and
but-
submitted through video conference.
Appearing for the appellant's
Advocate for the petition.
My lords, this matter pertains to election to the primary agricultural cooperative society, Antarsante, Mysore, my lords. I have preferred this writ appeal, seeking this honorable court to set aside the order dated 1/2/2025, which is passed in writ petition number 658 of 2025 by the learned single judge, my lords. I have filed 3 IAs, my lords. IA 1 of 25 is for stay and IA 2 of 25 is permission to prefer appeal, my lords. But by mistake, it is shown as impleading application in the cause list, my lord. So insofar as the IA 2 of 25 is concerned, my lord, the appellants herein are the impleading applicants in the writ petition number 658 of 2025 therein. And they are the appellant number 1 is the director of the respondent number 1 society, and all other appellants are the members of the society and who have interested in having election to be conducted in a fair and transparent manner and strictly in accordance with the provisions of the KCS Act and rules, my lords. The appellants herein have filed the caveat petition against the respondent number 1, but it was not made as a party in the writ petition. And when the same is brought to the notice of learned single judge, has directed the appellant to file the impleading application, my lords. And accordingly, IA number 1 of 25 has been filed. However, the learned single judge has ordered to consider the IA along with the main petition, but while disposing of the main petition, IA for impleading application has been rejected, my lords, without making the appellants herein as a party and without considering the contention took by the impleading applicants, my lords. So hence I request your lordship to permit this impleading applicants to challenge the order, my lords.
Who are you?
I am the director of one of the director of the respondent number 1 society and also members
You
of.
don't want election to be conducted.
No, my lords, I want to election to be conducted in a fair and transparent, my lords. Here, the respondent number 1 has not followed the procedure which is laid down in the KCS Act and particularly section Rule 13D2 of the KCS Act, my lords. Without following those procedure, they have started to announce the election notification, defaulter list, and eligible and non-eligible list, my lords, and including the villages which do not comes under the territorial jurisdiction of the Antarasante society and inclusion of the non-eligible voters, my lords. That is, that means to say they have not attended the annual general meetings, my lords. In the writ petition, in spite of bringing all these irregularities to the learned single judge,
In para 38 at page 48, this aspect is considered. Page 48, para 38 of learned single judge.
Sorry, man. Yes. Nothing. The application is dismissed. We'll consider the merits of the order and then dismiss your application as well.
my lords, may I
And,
make one
Or we
submission?
grant the application.
Election is
Notified,
also
ma'am.
underway.
Notified,
That's
my
the main
lord,
concern.
calendar of event is announced.
And which is the provision for election petition?
70.
Seven-
70.
70.
70.
But
give-
that is whatever the order passed by the learned single judge is contrary to the section 28D.
You challenge that in section 70.
70.
All ground.
My lords, in the identical matter, this honorable court has passed the judgment extending the election, my lords.
It can't be done.
My lords, may I produce that judgment, my lords?
Learn a single judge.
And also which was confirmed by the division bench of this honorable court, my lords. My lords, kindly peruse page number 15 for a moment, my lords.
Page number
15, my lords.
15.
May I read, my lords?
In this case, election process had started.
Everything has been done, but only thing is there is a irregularity which pertains to Rule 13D, my lords, in the same manner, my lords. And in the single bench has held that extended the time of the election, my lords.
Election had not started. We'll deal with. Next.
Number 27,
Yes,
Chand Pash.
Seal number 27. Learned single judge has said that the show cause notice will be treated as a demand of about 12 crores, my lord. This is actually under the PPP model. We've been granted the subway advertisement hoarding rights, my lord. And the agreement is at page, kindly see, my lord, page 51 is the agreement. Under the agreement, my lord, I was directed to maintain the subways. And for that, I had to pay 8,02,035. Page 52 may be seen. But this is not a case where an advertisement fee is rendered for advertisements. They give me about 22 subways for maintenance. And a concessionary fees is levied, a ground rent fees is levied ad hoc. Page 52 may be seen. Learned single judge said this may be treated as a notice, but said pay 50%. In similar matters, there is a stay with respect to concessionary fees and ground rent before learned single judge.
Page?
Page 144. The last page at seal number 13, 10-23. There is a stay in similar matters, series of matters, where the subways and skywalks are assigned and the ad hoc ground rent is fixed. Learned counsel, page 145, last page. Next page, the order portion. Learned counsel for the petitioner would submit, and in terms of the agreement entered into between the petitioner and the respondent, the petitioner is required to pay the ground rent of 5 lakhs for each skywalk, which the petitioner has paid and receipts for having paid and also placed on records as per annexure KM, RVT and P. On the other hand, Shri Pawan Kumar, learned counsel for the respondents, pointed out the ground rent would be 16 lakhs each year, as indicated under annexure. Demand notice are dated 5/12, but on perusal of the agreement placed on record at annexure would indicate the petitioner is required to pay an annual concession fee of 5 lakhs to rupees 7 lakhs for each skywalk. Shri Pawan Kumar, learned counsel for the respondent, is directed to get instructions with regard to the ground rent and what is the basis for indicating rupees 16 lakhs each year as ground rent under the demand notice at annexure A. Therefore, the court stays all these demand notices, my lord, and this is still pending. Kindly see the order. There were about 14 other matters which have been joined, batch matters. And the latest interim order is at page 142.
142.
142, about 2 pages earlier. Learned counsels for the party submits a dispute relates to the demand made insofar as skywalks and pleadings are yet to be completed. With liberty to the respondents to complete the pleadings, office is directed to list these petitions after 4 weeks. Interim order granted early, extended to be in force until the next date of hearing. And
What was the interim order?
interim order is stay of these demand notices.
Stay of?
Demand notices. But similarly, in my case, I have an agreement where I have to pay 8 lakhs for the entire skywalks. And I've been given the responsibility of maintaining it.
But this is.
Yes. My supplementary agreement is at page 52, my lord. Whatever is fixed under the agreement.
So this 6 lakh is.
6 crores, my lord.
Sorry, 6 crores is. Where from it the amount comes?
They have raised a demand notice. They have raised a demand notice contrary to the agreement.
No. What is the criteria for learn a single judge to require you to deposit 6?
Because the total was 12 crores, he said pay 50%. That was the, but
Then the
actually
petition is disposed of.
petition is disposed of, but treating the notice as a show cause notice. But as per the agreement, my lord,
PBMP has to come.
PBMP has to come.
yes,
Lord.
but as per the agreement, I have to pay only 8.
Third learned advocate.
To satisfy.
Third learned advocate,
Yes,
Mr.
please.
Your senior advocate.
Senior, yes.
Senior advocate Vivek Reddy for the petitioner, assisted by learned advocate so and learned additional government advocate, Mr. Paresh for the
For respond
petition.
number 1.
Full stop. Notice returnable on 24th March. Full stop.
Please.
From the impugned order of law and single judge, it could be seen that, it could be prima facie seen that the deposit of 6 crores directed by law and single judge has no quantitative basis, except it occurs to be 50% of the amount demanded in the demand notice. Full stop. Till the next date, the direction to deposit the amount shall remain state.
Please.
Full stop. So BBMP shall be served directly.
Please. We'll serve the BP. Please.
We find out some way on that day and dispose it.
Yes, my lord, please. There is a supplementary agreement fixing the rent, my lord. I have paid it regularly.
The single has done nothing except.
Yes, randomly fixing the
Yes.
price, please.
Is there any admitted amount?
No, my lord, all the admitted amount I have paid.
You have paid.
I have paid
So
regularly.
probably if that 6 crore is removed, you can't have any grievances.
No grievance.
So
Yes.
this notice
Yes,
has to be
yes.
adjudicated
Yes, let them decide on the merits, my lord.
in the
That-
presence of.
Please, please.
Commercial appeals, seal number 29 to Sukumaran G.
Lordship, that's the appellant was entered in an agreement with the respondent for constructing an agreement. It was about the total amount was entered into an agreement written and 2 lakh 2,57,54,000. Out of that,
It was a recovery suit,
recovery. Yes, ma'am.
not its returnable one. So finally, we'll have to,
Yes, ma'am.
23rd April.
Oblige.
December 30. HP Leeladhar.
See, recovery of the areas of rent and also eviction, Your Worship. The arrears of rent yearly 1,76,20,040 rupees. Your Worship. There is no dispute regarding the landlord and tenant. Occupation of the tenant, the tenanted premises is also not disputed. The honorable court says that I have to issue a notice during the COVID period for the termination of tenancy. On that ground, Your Worship, that the honorable court has been, trial court has been rejected the claim. And particularly, Your Worship, you see, the impugned judgment, Your Worship, is that the internal page 37, relevant portion is, Your Worship.
So this
38.
suit is, you are the original plaintiff.
I am the landlord, Your Worship.
Plaintiff.
Plaintiff appeal, Your Worship.
Then suit is decreed partly. Why you are filing?
Appeal, Your Worship, my claim, both the claim has been disputed. One is there is an arrears of rent of rupees 1,76,20,000 rupees. And also possession of the property.
Possession is granted.
Possession is granted
Sir, where
with
is
the
the plaint?
condition, Your Worship,
Where
you
is
have
the-
to deposit money.
Where is the plaint?
Well,
Where is the plaint?
yes, sir. Let us judgment. One second. Yes.
In the earlier matter also we'll call for the record. Earlier matter. The record shall be called for, so as to read this court before the next date, in the earlier matter, 29. Duty, notice returnable. 20, इसमें add करो. Add line. The registrar shall call for the record and proceedings from the court concerned, so as to reach this court before the next date. Same order in this also. 30th, also, identical. Make it 24th.
Serial number 31.
Serial number 31, I appear for the appellants in this matter, Lords. Its suit is in nature of money recovery, and this is the plaintiff's appeal, Your Lords, wherein which
Same order. You make it 28th April, 28th April.
32 urgent. Serial number 33. Vinod Gowda.
Money recovery manner. Here, the plaintiff appeal.
Decreed.
Partly decreed. I had filed the suit for recovery of the amount of 14 lakhs and odd. Here, the trial court has considered only the quotation issued by the defendant. I had done extra work, plastering work of the apartment, dependent apartment. Only 4 lakh and odd is awarded.
Same order. Same date, 28th.
Serial number 36, my lord.
30,
Serial number 36.
36, and what do you
Have it after 10 days, my lord.
after 10 days?
Yes.
My lord,
I inform the other side also.
All right, after 10 days, it will go to then
Only for they had complied certain direction. For that purpose, I had taken for time.
24th of March.
Much.
my lord, serial number 35 minutes. Short time, my lord, senior is unwell.
Short time, 1st April.
With your lord's kind permission, serial number 127, my lord. My lords, there is some urgency. Kindly fix a date at 2:30, please, my lord.
What is the matter?
My lord, it is against the single judge order with regard to section 128 amendment, my lord, to Cooperative Societies Act. Your lordship has heard that matter, my lord. Any convenient date as early as possible.
127.
127.
State appeal.
Your appeal.
Please, my lord, state appeal, my lord.
When do we want?
My lord, earliest possible date.
2:30, please.
25th of March.
Great.
Much obliged.
With my lords, kindly, serial number 115, my lords. It may called on Thursday, my lord, I will withdraw that on Thursday. I'll file memo tomorrow.
115 on Thursday.
Thursday.
6th.
Yes.
6th of March.
Lord, the matter at number 132, my lord, 230 list. I pay for the appellant, my lord. Lord, the matter at 126 and 132 arising out of the same order. Lordship, on the last state of hearing, my lord, has ordered to club the matter and to post the matter for the hearing. Lordship, I kindly club the matter of 126 and 132 and post the matter on day after tomorrow.
126 and 130.
Yes, ma'am. Arising out of the same order passed by the learners.
What is it about?
Lord?
What is it about?
Pardon me?
What's the subject matter?
Subject matter, Lord, the learner single judge, Lord, has passed an order directing, Lord, the government and Sangha to hold the election contrary to bylaw number 9 of the Sangha. That we have challenged, Lord.
So what is the request?
Lord, they have hastily starting the process the day after tomorrow, clubbing both matters. Your Lordship may kindly post the matter on day after tomorrow.
Oh, day after.
I make one submission, my lord. Serial number 127, my lords. My senior's name may be shown for respondent number 9, my lords. I'll pass on the name, my lord. The cause list. Serial number 126. With your lordship's permission. My senior's name may be shown for respondent number 9. my lords.
File not in the register.
Wakalat has been filed, my lord. Its name has not been shown in the cause list.
So we can't do anything. Registry will do whatever.
Yes. Serial number 129. Mr. Venkatesh S. Sarabati.
Along with that, Lord, I have given reference to some judgments along with para numbers.
That judgment compilation also, my lord, I am filing. For some of the judgment I have already referred to. ಅವ್ರಿಗೆ? Hmm. 16, 19. ಅಲ್ಲ ನನಗೆ Writ appeal 19, my lord. The order which came to be challenged was, there was an allegation that the concerned officer took bribe. On that basis, my lord, his explanation was sought. Found that there is sufficient evidence, a recommendation. Kindly see page 392 in writ appeal 19 of 2025.
How many appeals? Two appeals?
92 cases, my lord. One is 19 and 15. 392.
What is that?
Not there.
Ah.
This is the main order which was questioned.
Yes.
This is ordering departmental inquiry. This is the translated copy in bribe case against N. Ibrahim, assistant engineer, operation and maintenance subdivision. In this blood, after examining the matter, at page 396 is the recommendation of the Lokayukta. On that recommendation, enquiry is entrusted to Lokayukta. Page 396. Second para. The recommendation report of Honorable Upalokayukta 2 and FIR and final investigation report document consent to the case have been examined. Since it has found that Sri Ibrahim, junior engineer, has committed misconduct by receiving bribe from the complainant, therefore it has been ordered for departmental inquiry against said in the order dated 29/7/2017, handed over to Honorable Upalokayukta under Rule 14A, 1A1 of KEB servants, classification, discipline, control and appeal rules. N. Ibrahim, junior engineer, has submitted WP number so-and-so against departmental inquiry to Honorable High Court. And the Honorable Court has passed the order on 3/2/2020 as given below. The order impugned dated 29/7/2017 at Annexure P is set aside. Proceedings are restored to the file of respondent number 2 to examine the matter in terms of section 12(4) of the PC Act. Take a decision assigning reasons for arriving at such a decision. This exercise shall be made by the respondent number 2 in expedite manner. In any event, not later than 4 weeks from date of receipt of certified copy of the order for the writ petition stand disposed of accordingly. In the writ appeal number so filed by the Corporation in Divisional Bench of the Honorable High Court against the order passed by the Honorable High Court dated 3/2/20. Honorable High Court has passed following order. From perusal of the order dated 29/7/2017, is evident that no reasons have been assigned for arriving at the conclusion mentioned therein. The order dated 29/7/2017 reflects non-application of mind. Same is therefore rightly been quashed by the learned single judge. We do not find any ground to differ with the view taken by the learned single judge. However, liberty is reserved to the appellant to pass a fresh order within a further period of 4 weeks. In the context of the judgment of Honorable High Court dated 11/1/2023, in exercise of the powers conferred in order number KPTCL so and so, the documents have been examined in respect of bribe case against N. Ibrahim, assistant engineer, have been examined. N. Ibrahim, assistant engineer, while working in junior engineer post, Avanhaldi branch operation, maintenance subdivision of Mescom Sagara, has demanded bribe of rupees 5,000 for providing electricity connection to the 2 house and a commercial building, total 3 lines in the name of Jubaid Abi complaint. After examining all this entire allegation, they passed a fresh order at page 402, ordering departmental inquiry. Order is entrusted to Upalokayukta under Rule 14A1. This is pursuant to a remand order. Now, by virtue of this judgment, the entire proceeding goes and they cannot conduct the inquiry at all. The court, if you wanted to challenge, you should have challenged in the earlier round of litigation. After obtaining an order to apply their mind and to pass a fresh order, now the effect is Lokayukta cannot conduct the inquiry at all.
We'll hear them.
Please. Yes. May I please, I appear make an appearance for the petitioners, original petitioners for consent. There are 2 appeals notes, writ appeal. Lord, this is the interestment order notes after being remanded by the Honorable Lord's Court as such. May I just take notes in that page number 401. Notes, prior to that notes, I commenced notes with arguments. Notes, every notes inquiry notes commences from the notes report being submitted by the notes, either Honorable Lokayukta notes or Lokayukta under section 12(3) notes of the Karnataka Lokayukta Act. Notes may just state notes 12(3) of notes Karnataka Lokayukta Act. May I just read? If after investigation of any action involving grievance has been made, the Lokayukta or Upalokayukta is satisfied that such action has resulted in injustice or undue hardship to the complainant or to any other person, the Lokayukta or Upalokayukta shall, by a report in writing, recommend to the competent authority concerned that such injustice or hardship shall be remedied or addressed in such manner and in which such time as may be specified in the report. May I just take notes 3 is concerned, subsection 3. If after investigation of any action involving allegations has been made, the Lokayukta or Upalokayukta is satisfied that such allegations is substantiated. Notes may kindly appreciate. Involving an allegation has been made, the Lokayukta or Upalokayukta is satisfied that such allegations is substantiated either wholly or partly. He shall by report in writing communicate his findings and recommendations along with the relevant documents, materials, and other evidence to the competent authority. Therefore, notes by virtue of notes the 12th report, which is being drawn notes by the either notes by Honorable Lokayukta notes or Lokayukta, a prior notes opinion has already been drawn by the lordship's notes, the retired notes, the Lokayukta notes of Lokayukta is concerned. Now, this report notes has been forwarded to the notes, the department, that is not disciplinary authority. Now, disciplinary authority notes by taking into consideration notes the findings, the opinions, and the materials notes being taken into consideration, forms an opinion notes whether the matter can be referred or not. Now, in this case, note the writ appeal notes 19 is concerned. May the stake notes page number 347. In that regulation, notes I am bound notes, I am the KBTCL employee. I am bound notes the KB notes CCA regulations are concerned. Notes regulations 14A notes says that whenever notes in a report is forwarded to the department notes or the disciplinary authority may entrust the matter notes either to the Lokayukta notes or Lokayukta's concern. Therefore, discretion is left for the disciplinary authority notes. It may or may not notes refer to the Lokayukta local. I just notes read notes as regulation 14 later. Here notes what has happened is notes KBTCL notes is on their own notes have formed a notes appointed certain retired district judges notes for conducting an inquiry are concerned. But there are under various districts notes they have formed a retired district judges are concerned. Insofar as my case notes in writ appeal 19 is concerned, may the stake notes page number 347. In that notes on 15/7/2017, prior to notes the matter has been referred to the notes the Lokayukta or Lokayukta is concerned notes under regulation 14A. The matter of notes was already referred to not a retired district judge appointing one Srimati Kamala as a principal retired district judge for holding an inquiry. Now, prior to that notes when already been inquiry is commenced or notes entrusted the matter to retired Lokayukta or Lokayukta, there was no occasion for the notes for the department or disciplinary authority to entrust the matter notes once again to the notes Lokayukta's concern. That is my notes 1 point is concerned. Notes here, what happens is that the department notes never looks into this. What the department looks into notes sees the notes, the letter being written by the notes, Lokayukta notes or Lokayukta, then that is none other than 12th report. In that, saying that notes that please entrust an inquiry to us for conducting an inquiry. But this is notes where not the Honorable Single Judge notes has held that. Well, notes actually notes inevitable, but the concept note that is being arrived notes is that inevitable bias notes is concerned. Notes even assuming for the sake note that it has been referred notes, whatever the reference has been made is correct. Notes may kindly appreciate. And once then opinion is drawn, prima facie notes or notes by looking at the provision, it says substantiated. Substantiated the allegations being notes in the report is concerned. Notes in that concept, notes inquiries notes are being entrusted to notes the additional registers of inquiries, not for conducting inquiry, and to submit a report to the Lokayukta or Lokayukta is concerned. Now, the sole question that has been discussed not by the Honorable Single Judge in coming to the concept of notes inevitable bias is that when once an Lokayukta or Lokayukta has already formed an opinion or notes as already substantiated prima facie by saying that yes, allegations against the delinquent is there existing, can an additional list of inquiries notes working under them go contrary to the opinions that is being already been drawn by the Lokayukta or Lokayukta is concerned. This is where notes the court comes to conclusion that there is an inevitable bias notes on the part of an additional list of inquiries. They can't go beyond the notes the opinion already being drawn by notes by the higher authorities is concerned. Notes may kindly appreciate. Though notes inquiries is conducted by the assistant list of inquiries, they are not notes independent authorities. Like notes in the judicial system is concerned. Notes if any judgment degree is passed notes by any district judges or civil judges are concerned, they draw the final conclusion note that is judgmental decree. That is not subject to appeal. Here in this notes inquiries are concerned, notes whenever notes and report is submitted by the notes assistant list of inquiries, it's also been subject to scrutiny by the notes the lordship not by the Lokayukta or Lokayukta is concerned. Therefore, my notes humble request. I am not making notes any allegations notes against either Lokayukta notes or Lokayukta. Notes all that notes I am seeking notes is that I am protecting the interests of the petitioners are concerned. Notes the opinion notes the conclusions being drawn by the lordship's notes is that this is notes where the concept of notes inevitable bias comes into existence. May just read notes paragraph number 150. It commences notes paragraph 150, 151, 152 to 157. wherein, the lordships have come to conclusion that there's how the inevitable bias did exist, insofar these inquiries are concerned. May I just take Regulation 14A minutes that has been extracted minutes in in page number 37 in writ appeal minutes 15 of 2025. May I just read? Special procedures in certain cases. The following provision shall, notwithstanding anything contained in Regulation 10 to 11A and 13 be applicable for the purpose of proceeding against the board employees. Sir. Appeal number 15 of 2025. Page number 37.
Hold on.
Not good. Regulation 14A, that has been extracted. Please. 14A, special procedures in certain cases. The following provisions shall, notwithstanding anything contained in Regulation 10 to 11A and 13 be applicable for the purpose of proceeding against the board employees whose alleged misconduct has been investigated into by the Vigilance Commission or Lokayukta or Upalokayukta, either suo moto or in reference from the board or from any other authority, with where on investigation into any allegations against 1. A member of a board services group A, B, C, or D in respect of an allegations of serious nature, the Vigilance Commission, Lokayukta or Upalokayukta, or any officer of the Vigilance Commission, Lokayukta or Upalokayukta, authorized by him in writing and under sub-rule 2 of Rule 5 of the Karnataka State Vigilance Commission Rules 1980, Rule 12 of the Karnataka Lokayukta, this is important, Rule 12 of the Karnataka Lokayukta, Upalokayukta 1984, he is of the opinion that disciplinary proceeding shall be taken. He shall forward the record of investigation along with his recommendations to the board, and the board, after examining such records, may either direct an inquiry into such cases by the Vigilance Commission, Lokayukta or Upalokayukta, or direct an appropriate disciplinary authority to take action in accordance with the Regulation 12. Therefore, notice it is not the compulsion that the inquiry has to be entrusted not to the Lokayukta or Upalokayukta is concerned. A discretion is left to the disciplinary authority. Insofar as these two cases are concerned, much prior to the matter was entrusted to the Lokayukta or Upalokayukta for conducting inquiry. Already retired district judges were already been appointed much prior to it. Notes insofar as writ appeal 15 of 2019 2025 is concerned. Notes may just take notes paragraph number 9, page number 32 is concerned. 34 notes. In this case,
see the memo filed by the other side,
please,
showing the number of cases where it was held
not proved,
and recommended no action should be taken. That itself shows that there is no institutional bias.
Notes, notes insofar as notes arriving to the conclusion notes by the inquiry officers.
See, your contention, just because Lokayukta, Upalokayukta recommends and inquiry is entrusted to district judges.
No, I'm saying that when
there is an institutional bias, that's your contention.
When once an opinion is already been drawn notes by the Upalokayukta, by saying that yes, there is an allegation against him, so as to
the opinion is drawn to the extent that it's a fit case for conducting inquiry. That's all.
Nevertheless, not since when once an opinion is drawn, that's what not the inevitable bias in the
They are not going into the aspect whether it's a fit case to conduct an inquiry or not. They are going to inquire whether the allegations made therein are true or false.
My contention is that
Lokayukta, when it recommends, only looks into prima facie whether it is a fit case for conducting an inquiry or not. That's all.
but even my condition is that when once an opinion is drawn, can lower officers, the district judge concerned, can
The fact that in many of the cases it has been held that that charge is not proved shows that there is no institutional bias.
Please, even accepting that notes, insofar as my case is concerned, when once
You concede to that. There is no institutional bias.
I say that I suddenly justify the observations and the orders being passed with almost single is concerned. My case insofar as both these cases are concerned, much prior to the inquiry was interested to the Lokayukta, not basing on that report is concerned. It has already been interested to the retired district judges. There is no occasion for them to go or suspect any inquiry officers being already been appointed by the department is concerned. May just take note, para number 9. In the first case, in the year 2015 itself, the retired district judge was appointed for conducting inquiry. Then afterwards, basing on the report, this inquiry has been deviated to the Lokayukta is concerned. When once the inquiry has been already been entrusted to the retired district judges of the department, based on the discussion on the regulation 14A, there was no occasion for the department to, basing on the letter or report of the Lokayukta to entrust them. That's what my contention is. They are not suspecting the retired district judges whom they say that they are appointed as an inquiry officers for conducting inquiries. That's my my first point.
Who will conduct the inquiry?
No, they are retired district judges.
No, if you are right, then who will conduct?
Please.
So his contention that department. But subsequently it has been So your contention is that in your case, first a decision was taken to conduct a departmental inquiry by the KPTCL itself, by appointing a retired district judge. But thereafter, that decision was reversed and the matter was entrusted to Lokayukta.
Basing on the letter or report being submitted by the Lokayukta is concerned.
Correct. Did the inquiry commenced or what?
My instructions are that it was not yet commenced.
It had not yet
commenced. It had not commenced, so it was still not. Nevertheless, in para number 9,
anything in the bylaws of the
division bench has taken the view that in Shivanand Magdum's case, that wherever Lokayukta has forwarded the report, investigation has to be
conducted.
As departmental inquiry has to be done by Lokayukta.
But subsequent to that, this is not since our first case is concerned. On 11/7/2015 itself, the matter was entrusted to the retired district. Therefore, there was no occasion for the department to later on the year 2023 by basing on the report to revert back and say that you conduct the inquiry as such. Not say insofar as institutional bias, what has said. My arguments, which I convinced, that has been extracted in paragraph 150, 152, 157. And ultimately, the lordships come to conclusion that yes, there's an inevitable bias basing on this, the concept is concerned. And held that the regulation 14A is unconstitutional. Now, my second point of argument would be, so much of it have been canvassed by saying that there is the honorable single judge has passed in orders without there being pleading seconds. My earlier petition was only challenging the entrustment order. There was subsequently inquiry was conducted upon and in some first cases concerned inquiry report was submitted. There interim order was granted by the single judge. Though I produced the same note that was not taken into consideration. Then the lordships, the single judge said, the director of the department not to initiate an inquiry. This is not subsequent development. Basically, on subsequent developments, notes I filed an application seek for amendment of a writ petition. Notes calling out notes all these notes the regulations, challenging the notes veracity of the regulations 14A and 11A notes is concerned. And also notes making making a point by saying that this notes inevitable bias is concerned. That application was allowed, and writ petition was amended, and even the amended writ petition was also filed upon. Notes which they cutted by saying that though application was allowed, amendment was not carried out.
That point I'm not urging, my lord. We did not have a copy. We have produced. Amended writ petition is available.
Which notes I have produced notes in this particular case is concerned. There, if notes were to look into the paragraph notes 30 onwards, all these contentious notes which notes London Single Judge has taken into consideration, all these points notes have been raised upon. Basing on that notes, the Honorable Single Judge notes has given an answer to this subject. Therefore, notes by saying that without pleadings, note the Honorable Single Judge has passed an order, but that does not stand notes correct. Notes, my notes, another notes, double jeopardy notes which the lordships have held. Notes why the concept of a double jeopardy has come to conclusion.
You are relying on sub-article 2 of 20.
Notes what happens is that basically on the same allegations, notes one proceedings will be notes the criminal cases concerned. That is notes under the Prevention of a Corruption Act. Another notes.
Sir, it's an established principle of law. One event gives rise to civil cause of action, which is disciplinary proceedings. The same event can give rise to, not necessarily, can give rise to a criminal offense.
Please.
Under PC Act, if a person is trapped.
Please, my arguments would be same.
Where is the question of 20 clause?
Same records, same witnesses notes have been examined on both notes.
Correct. And time and again, Supreme Court has also held that both aspects can go on together.
Please.
And if there is an honorable acquittal in criminal case, disciplinary proceedings need not proceed.
Please.
And it has also been held there, its burden of proof is beyond reasonable doubt.
Probabilities.
Here it is based on balance of probabilities. Just because an action gives rise to a disciplinary inquiry being initiated by Lokayukta, and another aspect under PC Act by Lokayukta police, you can't say 22 is attracted.
Notes. My arguments will be notes suddenly to justify notes the conclusion being drawn notes of the Honorable Single Judge is concerned. Notes both notes taken into consideration both the criminal cases notes as well as notes the department inquiries, basically the same set of records, same set of witnesses, same set of evidences. Of course,
it can't be. If it is something else, then there is something wrong.
Please.
It has to be same allegation of facts and same witnesses.
Please. My next point of notes arguments would be notes are pleased to raise a question in the last occasion. Whether notes even the police wing comes under the notes of the purview of the Karnataka Lokayukta are concerned. May the take notes in the statement of objections is concerned. Notes page 390 notes. Page 390. 390. The statement of objections filed with the Lokayukta. Para 5 notes regarding para number 5 and 15. It is relevant to contend that KPTCL not supported. Notes in writ appeal 15 of 2020. Please. It is irrelevant to contend that the KPTCL on 5/7/2017 has issued a notification by appointing a retired principal district judge, session judge, and inquiry officer. It is also irrelevant to contend by the counsel for the petitioner submitting a memo dated 2/11/2023, along with the order dated 4/11/2020, whereby the board of directors of the KPTCL have resolved and passed an order thereby inserting regulation 14A2 to the KPTCL employees, classification, disciplinary, and appeal regulations 1987, whereby in case of a receipt of a records of investigation carried out by the Anti-Corruption Bureau, in draft cases, the disciplinary authority shall examine the records for taking further action. Thereafter, the disciplinary authority should issue a charge sheet under regulation if prima facie evidence for misconduct is found. Thereafter, the disciplinary authority shall appoint a retired judge who is a district and a session judge to conduct an inquiry and submit a report. It is submitted that in relation to the order dated 4/11/2017, bearing number so and so of the KPTCL, the said order and regulations are applicable to only in cases where investigation of the misconduct of KPTCL employees have been conducted by the Anti-Corruption Bureau in ACB. In the instant case, FIR dated 2/11/2014 in crime number 13 of 2024 was registered by the investigation officer of the Karnataka Lokayukta. The investigation has been taken by the investigation officer attached to the Karnataka Lokayukta. The investigation was also completed by the by filing a final report by the investigation officer of the Karnataka Lokayukta before the jurisdictional court. It is also relevant to note that though ACB formed established by virtue of a government order dated 14/3/2016, since the FIR in the instant case registered by the investigation officer of the Karnataka Lokayukta, the same investigation also took by the investigation of the Karnataka Lokayukta, hence order dated so and so regulations. Notes they virtually notes admit by saying that notes even the police wing, which they say, of course they got a control over notes the administrative control is concerned. Insofar as the police wing also notes they have got control over this aspect. Therefore, notes the both in the criminal cases, the very same authority notes investigation officer does conduct an inquiry. Even notes in the department inquiry notes whatever the materials that is being taken out, that is all being done by the notes the police authorities. Therefore, notes the Lokayukta institution notes headed by the Lokayukta. He is having notes control over notes all the wings. Therefore, notes even taking into consideration this aspect also. Individual bias note which the lordships have held in single judge note, that also notes applicable insofar as this contention. Then notes notes insofar as first case writ appeal 15 of 2025. Notes in that case notes inquiry was notes already commenced upon by the notes before the Lokayukta institution. Notes report was also submitted and the recommendation also submitted. Notes my contention is that insofar as the recommendation is concerned, notes the recommendation along with the punishment notes is not per se bad enough. Note what happens is that recommendation, of course, the lordships will notes if the report were to say yes by saying that yes, this is what the inquiry officer has given the report, kindly do the further action. That would have been sufficient. What the lordships does is notes that the recommendation along with the punishment by saying that you compulsory retirement or all notes the dismissal is concerned. This recommendation notes along with the punishment notes is per se notes bad in law. That is what meant. What happens is that notes it curtails notes the independent action to be taken by the disciplinary authorities. Though it forms an opinion, though it says notes it's a recommendation, nevertheless notes it influences the disciplinary authority in coming to independently come to the conclusion about the punishment to be imposed or not to the disciplinary authorities. Therefore, note this, what the single judge has held. By virtue of this recommendation, the Lokayukta institution, notes instead of recommending authority, notes has said the use of the word. Adjudicating authority. Instead of notes recommending authority, notes the Lokayukta notes institution has become notes an adjudicating authority. That is notes correct authority. How? Not influences. Notes added being sent report by saying that yes, this is what my report is concerned. Notes disciplinary authority notes would have taken an independent action, notes by applying the independent minds. This by saying that yes, we got to kindly appreciate the rules. Section 12 further states if an action is not taken within 3 months of notes of the report is concerned, then the Lokayukta can submit notes, can intimate to the governor, and the further action can be taken against him. Therefore, notes this holding of an notes action to be taken by the disciplinary authority. First, notes along with the recommendation, punishments. Then, notes subsequently by saying that yes, if not taken, notes will initiate an action against the disciplinary authority. This notes virtually controls the mindset of notes of disciplinary authority is concerned. All that notes what is the law is that based on the report, based on the materials, the disciplinary authority has to independently come to conclusion whether notes punishment can be imposed or not. This notes influences recommendation along with the punishment, imposes notes restrictions or influences the mindset of notes of disciplinary authority is concerned. Therefore, not this notes. I'm saying that whatever the law, how the lawships have come, that is not correct. Then notes my sole case is that insofar as the second case is concerned, writ appeal 19, notes inquiries notes what commenced not, but because of this stay order not that has been stopped. Therefore, insofar first case is concerned, notes recommendation along with the punishment notes is per se notes is bad. Notes the rest of all notes notes virtually do not want to make an allegations against notes Lokayucta, Uplokaita, notes. All that notes I want is not interest to protect the interests of the petitions. Therefore, notes I relied notes before the Hanba court, single judge from certain authorities, which notes I also relied notes. This is also pertaining to
Giving synopsis,
I'm not list of authorities, petitions.
not giving synopsis.
Notes I'll be notes within 2 days.
Can do within 2 days,
Wait, I'll submit.
but not beyond that.
Yeah, I will submit by day after tomorrow.
You are for whom?
My submission will be very limited, my lords, that all the aspects have been done. My submissions will be limited, my lords, to that of the bias. My lords, only thing is on the concept of bias, my lords, what the Honorable Apex Court has held, especially in terms of Lokayukta also. My lords, in this matter, my lords, the learned single judge goes on the concept of inevitable bias, holding the fundamentals of likelihood of bias, my lords. But the very judgments which the learned single judge relies upon, the Honorable Apex Court has held that likelihood of bias definition, my lords, there is likelihood of bias when there is personal bias. Otherwise, it cannot amount to likelihood of bias, my lords. That is the basis. Therefore, there cannot be inevitable bias in an institution, my lords, is my respectful submission in a gist. Now, my lords, the first definition, the first case, my lords, is a matter, my lords, in the criminal wing of Lokayukta itself. The informant was that of a police officer of Lokayukta, and the investigation was done by a senior officer of the informant. Then the aspect of bias was argued before the Apex Court. Apex Court said very clearly that in an institution of the same wing also, if there are different officers, it does not amount to bias. My lords may kindly see page 34 at page, para 34 of page 10 of that judgment, my lords. This is pertaining to Odisha Lokayukta. May I read, my lords? So far as the objection raised by the respondents regarding the action of conducting preliminary inquiry being biased for the reason that the Deputy Superintendent of Police of the Directorate of Vigilance has submitted a complaint and the appellant directed the Directorate of, I'm sorry, page 10.
Yes.
Paragraph 34 at the bottom.
Yes.
So far as the objection raised by the respondents regarding the action of conducting preliminary inquiry being biased for the reason that the Deputy Superintendent of Police of the Directorate of Vigilance has submitted a complaint and the appellant directed the Directorate of Vigilance to conduct a preliminary inquiry by an order dated 11th December 2020, which in fact was conducted by a senior officer of the Directorate of Vigilance, Additional Superintendent of Police Vigilance, Mr. So-and-so, who submitted a report to the appellant on 28th May 21 is concerned. We are not persuaded with the submission of there being any bias on the part of the Directorate of Vigilance cell in conducting preliminary inquiry for the reason that the officer who submitted a complaint was simply an informant and not the person interested. At the same time, preliminary inquiry was conducted by a different officer, not connected with author of the complaint. Thus, the plea of bias was ill-founded. In our view, the principles of bias even remotely are not attracted to the facts and circumstances of the present case. This, my lords, refers to, now kindly see para 36. This judgment refers to Ashok Kumar Yadav, a constitution bench of the Honorable Apex Court at para 36, my lords, where the learned single judge also relies on the same judgment to hold that inevitable bias, my lords. Para 16. The first 5 lines I will read, my lords. We agree that the petitioners that it is one of the fundamental principles of our jurisprudence that no man can be judge in his own cause, and that if there is a reasonable likelihood of bias, it is in accordance with natural justice and common sense that the judgment likely to be so biased should be incapacitated from sitting. Now, my lords, may kindly see page 13. In the bottom, my lords, just before para 37, the judgment itself emphasizes and is underlined. My lords, get it? This court emphasized that. This court emphasized that it is not necessary to establish bias, but it was sufficient to invalidate the selection process if it could be shown that there was reasonable likelihood of bias. Now, my lords, the definition, the likelihood of bias may arise on account of proprietary interest or on account of personal reasons, such as hostility to one party or personal friendship or family relation with others. This was the basis. Personal bias. Therefore, my lords, when the different wing, this is the main contention, my lords, and there the laws also have changed to say
The entire reasoning of learned single judge centers around this concept.
yes, yes, my lords. That is all I want to show, my lords. The rest of the thing falls basis this.
My lord, we shall be filing a written synopsis, my lord. Couple of days we'll file it.
So heard learned senior.
Ready, my lord, I'm awaiting the approval from the department. The synopsis is kept ready. We did not have opportunity. We were not party in this.
This also you need the approval of the department.
No, my lord, the reason being, my lord, in the writ petition, we were not arrayed as the party. We had no occasion to file our statement of objections. So they would like to take a specific stand, my lord, in the matter. A couple of days' time, my lord, we will.
Mr. This is an appeal.
I understand, my lord. The reason from my lord, I have just received a communication requesting for, in fact, I was kept ready the written synopsis, my lord. In fact, everything was
sent to appear and intervene.
No, my lord, they want to review this written submission, my lord. Therefore, I am seeking short accommodation.
No, will not take.
The lordship may proceed to reserve it, my lord. Next couple of days, I will file it in the registry. my lord.
No, it is out of procedure. How can you submit a written synopsis when you are not a party?
No, my lord, in the writ
Without
appeal,
becoming-
writ appeal, we have been arrayed, my lord.
Without getting yourself implicated as party.
My lord, writ appeal, we have been arrayed, my lord, pursuant to the orders passed by lordship. In the writ petitions, we were not the parties, my lord.
You have passed it.
No, my lord, in the writ petition, we were not party. My lord. Lordship passed an order impleading us as one of the respondents because lordship wanted to know our stand in the matter.
Heard learned senior advocate Mr. Ashok Karnataka, assisted by learned advocate Mr. So-and-so for the appellant, learned advocate Mr. G. Nataraj for respond number 1.
No, sir, respond number 6, first cases.
For respond number 6. So the parties are identically arraigned in both the appeals?
In all 3 appeals.
3 appeals?
3. We have
Three-
filed an appeal, third one.
Blood, my
3 appeals?
Same
same
judge.
judgment, blood. There are two blood, different DGOs, two different writ petitions. Blood, we filed 2 writ appeals, blood.
So all 3 appeals.
My-
Heard learned senior advocate Mr. Ashok Karnataka, assisted by learned counsel for the appellant. Who is the appellant, the other petition?
The corporation has filed one.
So have the appearances of all? Come heard at length. Learned counsels for the respective parties in all three appeals stated that they argued the appeal finally. They further stated that the pleadings are complete and no further are required to be added or supplemented. Full stop, paragraph, reserved for judgment.
Liberty for me, my lord,
Court leave.
to place my written submission.
So who says no?
Please.
But within 2 days.
2 days.
After 2 days, we will not accept.
Grateful, my lord.
Even
It's kept ready, my lord. In fact, I'm
accepting
ready.
the submissions after conclusion of arguments is not.
No, my lord, I'm not
regular,
accepting.
but
for-
we are giving that liberty.
Grateful.
Yes.
Grateful.
Seal number 132 is urgent. Seal number 133, Mr. S.V. Bhatt.
What is it? 133?
It's for compliance today.
I'm appearing for accused to your lordship.
So,
My lordship, we are waiting for instructions for compliance of orders. your
second
lordship.
April,
Kindly give us time, your lordship.
yes. Next.
Seal number 134. Vijay Kumar.
This matter, my lords, it has been partly complied, my lords.
Nobody is there. None present for the complainant. Stand over to 24th of April.
Number 135.
I'm for the complainant, your lordship. Copies.
Empty mic, what are you saying?
On 18/2/2025, my lords, they have filed a memo with the support of photograph, my lords, that there is an encroachment on the land in question, my lords. With regard to that, my lord, I'm filing my reply, my lord, to state that the action taken by the authorities and my lords, and what is the factual position over there, my lords. Copies also served, my lord.
Copies not.
The main grievance of the complainant, my lords, that there is a bund put across the flow of the natural stream, my lords. That is the main case, my lords. To that effect, my lord, there is already a compliance has been done, my lords, with removal of the said bund, my lords. For a moment, your lordship may kindly see page number 31, annexure R14, which presently I have relied upon, which is a representation given by the complainant to the authorities, my lords. At page 31, annexure R14, my lords, if your lordship sees the subject column, my lords, they say that requisition to open the bund put across the natural stream by private person diverting water to her tank and to restore the natural flow of the water as before. That is the only grievance, my lords, that the complainant was facing. To that effect, my lord, the bund has been removed, which was in the natural flow.
Your lordship, page number 33, very clearly I have mentioned encroach the fire fence further by barbed wire fence in order to construct a private road to her tank situated on her property. The said Viju there has engaged heavy equipment to erase the fire fence and is constructing a motorable road on the said piece of forest land to her tank and has brought large volume of mud and fully blocked the stream to deprive me and similarly placed farmers and cattle of water in violation of the Forest Act.
I have given several representation, second, third, and fourth of you, but you have neither taken any action, stopped the construction, nor taken any action in response to my representation. Hence, I am requesting your good selves to consider my representation immediately and allow the free flow of the water in the natural, and also stop the said Srimati KV by encroaching and putting up a private road on the forest land and obliged. It is very clearly I have mentioned that the putting up of a private road. And my representation also, from the day one, it is very clear that where she has encroached the swamp. And these forest officials allowed her to put mud on that swamp and completely closed and formed a private road. That is my grievance. And I have produced the photographs right from the beginning when she started putting up the private road on that swamp with the heavy machineries and dumping the mud and all. I have been requesting the officials. And this road was made only to facilitate her to reach to the bund where she could irrigate to her property by putting her machine on that land only to irrigate her property. And my photographs are very clearly shows that. And the commissioner, along with my rejoinder, I have filed my commissioner report also, Your Honor, Your Lordships, wherein very clearly the commissioner also said that, along with my rejoinder, if I could take Your Lordships.
Well, like for orders. On, keep it on. Today is what? Seventeenth March.
Please.
Number 136. The Sheriff is good.
The order of which disobedience is alleged is at page 13 and 14, my lords. Request for effecting kata. My lord, the order of which disobedience is alleged is at page 12. May I invite your lordship attention to page 14, para 4. And direction to consider the representation within an outer limit of 3 months. On 7/2/25, if your lordship peruses the order sheet on 7/2/25, your lordship had noted their submission that they would comply with the orders. On 7/2/25.
Disregard, my lords, on lordship had made a submission, my lords. They have made special Tahsildar Bangalore North Taluk as a party, my lord. They have made special Tahsildar Bangalore North Taluk as a party, my lords. The jurisdiction lies before the Yelahanka special Tahsildar, my lords. And I had made a submission that presently the said post is vacant, my lords. Now the government has taken steps to appoint a special Tahsildar said post, my lord. For that, I require compliance will be done, my lords. But till the special Tahsildar post is kept vacant, as no appointment has been given, my lords. The case is that we cannot be considered, my lord. The thing is that the concerned person is not still not appointed. I pray for short accommodation, my lords. Meanwhile, the government has taken steps to appoint a special Tahsildar to the said post, and compliance will be done, my lords.
But he must be in charge.
I have inquired, my lord, still the charges are not given. Even I got a recent mail communication, my lord, still the charges not being given, my lords.
The order is passed on 20 June 2024, my lord.
Okay, my lord, there is a lapse on the part of the authority.
Higher authority must be there.
My lords.
Some higher authority must be there.
Please, my lord, to
Assistant
that
Commissioner.
effect, my lords, see, only for the Bangalore, my lord, the post is created, my special Tahsildar. In the rest of the district, my lords, only Tahsildar is there, my lords. Only for Bangalore, that post is there, my lords. The said the person who has to affect the kata, my lords, is kept under for various reasons, my lords. Presently, it is vacant, my lords. Compliance will be done. Now the government has taken steps to appoint a special Tahsildar to the post, my lords. My humble submission, my lords, if short time is granted, my lords, the compliance of the complainant will be redressed, my lords. That is my humble request, my lords.
Only case of Pauti kata, my lords, inheritance kata.
So nobody is there to hold the charge of Tehsildar.
Special Tahsildar, my lords.
Favorite.
Please, my lords.
Nobody is there.
Still the post, there still no appointment has been given to the said
Okay.
post, my lords.
So who is handling the affairs of the
No.
office of Tehsildar?
It's
Special Tehsildar.
everything has been still kept pending. Tahsildar is performing his duties, whichever is pertaining to his jurisdiction, my lords. Few facts, my lords, things are only has to be done by the special Tahsildar is the thing, my lord. My humble submission, my lords, if short accommodation is given, my lords, we see that the compliance will be done of the complainant, my lords. That is my humble request, my lord.
How will you do sort? How will you do?
No,
complaint?
now the government has been taking.
Of Tehsildar.
No. Now the government is taking steps to appoint a special Tahsildar to that post, my lords,
When?
because, my lords.
When you will be appointed?
My instruction, my lords, at least minimum 4 weeks time is required, my lords.
No.
If
that
short
is-
accommodation is given, my lords,
Let the deputy commissioner be here, either personally or through. This is not done, Mr.
my request, my lords, if short time accommodation is given, my lords, will redress the,
Not a short time. And when you make a statement that you will be reporting.
Yes.
compliance.
please, I agree, my lord.
I am not
No, my lords.
getting, I said the same thing that.
Please,
to
my lord.
higher officer.
A short accommodation is given, my lords, a reasonable time is granted with honorable court, my lord. We see that the grievance has been redressed, my lords.
State is a pro forma respondent, my lords, in this contempt petition also. State is a pro forma respondent. Okay, lords, and
See, in contempt matters, I don't know how a government advocate is representing the accused. See, in contempt, it's an allegation made on the accused that he has disobeyed the orders of this court in his personal capacity. And he has to engage the services of an advocate. State is only a pro forma party. In all these matters, we are seeing that you are appearing. How is that it's happening? How is the AG office permitting government advocates to represent?
In Gujarat, an order was passed by one of the honorable judges that don't appear.
The practice is, my lords, until the practice is, my lords, until framing of charges, government advocate appears. It's been so all along.
When?
Lords, it's been all along like that.
It's not like that.
But in other states, my lords, I agree that they are
He-
represented by
once-
the private
Once
counsel.
notice goes, it's, he has to engage the services of a private advocate. Once he receives the notice, he has to engage the services of a private advocate. You can assist, that's all.
But the practice has been that. my
It's
lords,
not the
I'm just
practice, madam.
putting the-
That's not the practice. Even when someone is representing an institution, a managing director or for example, special land acquisition officer or KADB or BDA or whatever, their counsel, unless they get a personal wakalat from the accused, they cannot represent.
Therefore, when we are receiving the notice, we only receive on behalf of the pro forma.
Exactly. And you are conducting it as though it's a writ petition.
yes, yes, my lords. That's the
And the question of charge not being given to some other person is something unimaginable. When someone gets transferred or that person is retired, invariably he hands over charge to someone else.
Who is the next higher authority? Deputy commissioner?
assistant commissioner,
The,
assistant commissioner.
Not party.
My lords, he was the party in the writ proceedings.
that's in Yelahanka Taluk, my lords, the work is divided like this. Tashildar, regular
this-
Tashildar handles all the
Right.
grant matters.
On last occasion, the this court recorded a statement of learned additional government advocate that he will be reporting compliance of the directions of learned single judge contained in order dated 20th June 2024 in writ petition number 15792 of 2024, which are the subject matter of present contempt proceedings. Full stop. Any of the statement made by learned additional government advocate. The contempt petition was specially listed at 2:30 since the compliance was to be reported. Full stop. Today, when the petition came up for consideration, learned additional government advocate paragraph. Today, when the Mr. Raghavendra stated that the stated with turn around submission, that turn around dash submission, that the post of respondent 4, that's the special Tehsildar, Bengaluru, who is to carry out the direction, is vacant, and since there is nobody functioning on the post to discharge the duties of special Tehsildar, the order could not be complied with. He submitted that 4 weeks time may be granted. Full stop. When asked whether within 4 weeks the appointment will be made, learned additional government advocate was entirely at his receiving end. Paragraph. It is beyond, it is not fathomable, paragraph, that the office of the special Tehsildar is vacant in such a way that even nobody is handed over the charge to function temporarily as to perform the duties of the special Tehsildar. Full stop. The sorry state of affairs, having noticed the sorry state of affairs, respondent 3, that's the Assistant Commissioner, Bengaluru, North Division, Bengaluru, is directed to file personal affidavit to state before the court as to in what circumstances and as to why the office of special Tehsildar is kept vacant, as to why nobody is appointed, and as to why none of the officers is handed over charge to function to discharge the duties and function as special Tehsildar in absence of the regular appointment, which because of which the public at large suffers. Full stop. Such affidavits shall be filed on or before next date. Put up the petition on 17th March. Full stop. It is observed that if the affidavit is not satisfactory, the court will take a serious view of the matter. Now we'll pursue this to logical end. We are not able to understand that nobody is functioning. And if it is so, then it is highly deprecable. And we will not permit that. Office of special in the city of Bengaluru is vacant and nobody is working. And you have no answer that when he is going to be appointed?
On an in-charge basis, some other officers will be working, my lords. It can't be left vacant because there's huge prime post.
That's
My submission was that, my if short accommodation is given, my lords, we will comply it, my lords. That was my submission, my lords. If short, one last opportunity is given, my lords.
You only need to take proper instruction. Had you taken a proper instruction, this order would not have ensued.
No, my lord, as per the
Still,
instruction.
you can take proper instruction and nullify our order. It is only for you to
In
respond.
the afternoon, I got an email.
To respond properly.
I'll take instruction, my lord. Even at the same time, even by afternoon, I got an email, my lords, on continuous follow-ups, my lord. I have gotten an email, my lord, that post was vacant. My submission was that, my lord, if small accommodation is granted, my lord, in that time, I would have been compliant the
How many accommodation?
one last accommodation, my lords.
No.
Because this was my recent email which I got it at 2:30 PM, my lords. From morning, after continuous follow-ups, my lords, it was requested that Our still appointment has not been made and one last opportunity was sought to comply the order.
The order is passed on 7/2, my lords. They cannot take instructions today.
Not that, not to.
And
work,
the
my lords,
order
but
of the
to
learned
comply
single
the-
judge is in June 2024.
So what will you do in the next day?
My instructions was that, my lords, now the government has taken steps to appoint the special tahsildar. As soon as then, my lords, the grievance of the complainant would be addressed, my lord.
But he must be functioning.
My lords, my submission with regard to special tahsildar, my lord, that work cannot be things, my lord, because that only in Bangalore region, the special tahsildar post has been created, my lords. In the rest of the parts, it's only tahsildar who functions all these works, my lord.
We are not prepared to believe, nor will permit ourselves to believe. We are not prepared to believe, nor we permit ourselves to believe that nobody is functioning. Or you can keep the post vacant.
In short accommodation, my lords, will.
What will you do after short accommodation? Tell immediately, we are running short of time. Lot of matters have to be attended, yes? And this all happens because you are not.
Action has been taken to appoint a special tahsildar, my lords. That will be, that I'll be reported and the compliance will be done, my lords, in the next date of hearing.
No. If you are going to tell us that who is functioning as in charge, then tomorrow at 2:30. Otherwise not.
That is secure instructions, my lords. Who is kept in charge, I'll take instruction, my lords.
Otherwise, this order will remain.
May I have it tomorrow, my lords. I'll ask who has taken the in charge, my lords, because.
Come at tomorrow at 11, tomorrow at 11. Keep this order type ready. If you are not giving any satisfactory answer, this order will remain.
Yes, ma'am. I'll report
Tomorrow
it.
at 11.
Tomorrow I'll report it. Yes, ma'am.
Bill number 137, Mr. TP Muttana.
Yes. Why this is kept at 2:30, Mr.
My lord, it was only short question, my lord. This matter, my lord, that in this matter, my lord, during 1956-57, the Karnataka Housing Board constructed about 46 flats and given to the government company. And subsequently, my lord, that
Notice has not come back? Await the notice.
representing my lord, advocate.
For some of the respondents' notice, I have yet to file wakalat. And
File wakalat, no.
2 weeks time may be granted for.
Like 10 over to 26th of March.
But this, in this matter, the appellant has filed an application stating that the earlier government order has been withdrawn. This pointed questions was raised by the single judge asking the government advocate, and the government advocate said that is improper. Now the recall order which is filed along with the application says that cabinet approval was not there. But your last may kindly direct the government advocate to secure records regarding 2009 government notification as well as the present notification, whether this has a cabinet approval or not. The entire proceedings it can be, government advocate can be secured so that it will be beneficial for.
My lord, if there is an order placed, my lord, to show that it has been withdrawn, my lord, end of the day.
No, this
My
records
lord,
finding.
if my lord
after filing your
disputes with that-
Please.
Yes, next.
Bill number 34. Mr. Ashok Banipini.
Delay.
May be condoned.
Delay is condoned. What is the, any urgency and we will keep the
Lord,
appeal on the other, some other day.
May make one submission, my lord, with you.
Yes.
It has become infructuous, my lord, for this reason, my lord. The order of after passing the order of single judgment, we have already followed the procedure and work order has been issued, my lord. So it has become infructuous, my lord.
My lord, the red petition has not followed the principles.
You participated in the tender, first tender?
No, but my lord, they've increased the finance capability bar. They restricted me in participating, my lord.
They did not participate.
They restricted me in participating because
Not
they raised the bar.
We did not restrict anyone.
Because I am only an NGO, my lord. My capacity is limited.
Then what? They are within the right to fix the criteria, eligibility criteria. So effectively what survives?
My lord, my rights are curbed, my lord, because of this, see, my lord, the page number 25 of the writ
So
petition
delay is
order.
gone down. Delay is gone down. The appeal will be listed on 18.
My lord, this is my writ appeal is rejected because saying that, okay, cabinet approval is not there, my lord. The same respondent number 2 and 3 have submitted saying that this is.
Let us see what was the prayer in the main petition.
Because it was already passed in the budget, my lord. When it is passed in the budget, cabinet approval is not required unless there is an escalation in the financial requirement, my lord. The whole writ petition is
So
not
tender,
as per law, my lord.
tender was, it was against cancellation of tender.
Cancellation of tender.
Yeah.
You wanted that the work order should be awarded to you.
Yes, my
Now the petition is rejected. In the meantime, the press tender is issued. You are permitted to participate. You did not participate.
My
That's
lord, but
Now-
they raise the bar, my lord. See, the petition was rejected on the grounds that, okay, the cabinet approval is required, my lord. See, what they have done is cancellation of the tender was based on some complaints were received, my lord.
Now what effective relief can be granted in this petition?
My lord, I should be allowed to participate in this, my lord, because I've already.
It is over.
Order is issued.
You
my
put
lord.
on the affidavit that the press.
Please, my
tender
lord,
and the work
I
is
will
awarded.
take in-
And the work order is also given.
Please, my lord,
to
work
new-
order is also.
new-
My lord, I received the information I have in the,
Do it.
this one.
So
See,
today-
that only I have.
Today it is delay is condoned and petition appeal shall be listed on, when you will file? 18th,
Please, my lord,
18th.
please,
We listed at 2:30.
please. my lord.
35, 36 are urgent. Number 37, the state appeal.
There is a delay, my lord, in filing the appeal.
So 355 days of delay,
Please, my lord, there's a delay of 350.
so much.
Some time for filing objections, my lord, 3 applications filed. The writ petition order, my lord, to issue the Sagabari sheet based on the recommendations by the committee, my lord. And occupancy price was also received by the government. In the year of 2004, the order was passed. After receipt of the occupancy price, Sagabari sheet was not issued. That is a writ of mandamus, my lord. The single judge has passed the order. Issue the Sagabari sheet.
Too serious.
My lord, lordship, may kindly have it next week, my lord. I will make my submissions, my lord. Kindly have it next week, my lord. Because, my lord, we are seeking for production of certain additional documents also, my lord. On parity, my lord, this order has been passed because the three other people are covered under the OMs. Kindly grant short accommodation.
The
my lord.
very same point, my lord, this honorable court passed the order under 108 D3, my lord.
Weeks accommodation. my lord.
2004, he was granted the land.
I understand, my lord.
Correct. He has paid the upset price after grant of the land.
My lord,
Now,
the only reason assigned, my lord, is regarding.
similarly situated persons in the same notification, along with whom others were granted the land, they have been issued Sagavali check.
On parity, this order has been passed.
The petitioner has not been issued the Sagavali check. Later on in the year 2015, you come up with regulations saying that the land is situated within a radius of 5 kilometers. So, Sagavali check cannot be issued. How is it justified?
Weeks accommodation, my lord, because I'm not trying to support the appeal grounds, my lord, in fact. Weeks accommodation, my lord.
Why?
Next week, anytime, my lord.
Why we can?
I will secure instructions from my lord why this decision to file an appeal has been preferred in the matter.
Don't have the paper.
No, my lord, I have secured, I have to go through the papers, my lord, because certain additional documents are sought to be produced here. If it makes a difference, my lord, I would have a case, otherwise, no, my lord.
So not read.
I have not read that, my lord. The documents. I
Very
go through
same
that,
set
my-
of facts,
A week's
my lord.
accommodation, my lord, I will present my case,
That-
my lord. If there's no case, I will not be pursuing.
This honorable court passes the order on the very same set of
So
facts.
you do not read, because you do not have the instruction. Because you do not have, or you are not able to take instruction. Or you want not to conduct the matter. We have to read thrice, fourth time, fifth time.
No, I will not trouble your lordship. Next day, next hearing. Next hearing date, I will go ahead, my lord. I will not trouble your lordship. If there is no case, my lord, I will concede on that point, my lord, because on parity, others have been granted under the same OM, my lord. I will not stand to justify these grounds, my lord. End of the day, if that is the case.
So in half of the matters on the board, we are suffering double G.
I understand.
Tell you.
Short accommodation.
12th at 2:30.
Grateful.
At the request of learned us.
If there's no case, at least let me persuade, my lord. If there's no case, at least let me persuade the officers, my lord. Because there's no point suffering an order for the hands of this honorable court, end of the day. Let me have a word with the officers, my lord. That is the intention.
Even the delay condonation is drafted
There's no, there's no reason assigned in the affidavit also, my lord.
So
I
you
understand.
know, go to. Yes, next.
Sorry, my lord.
Number 38.
For upright, my lord. Madam, the matter is this is for non-prosecution, my lord. IA is filed, my lord. That is not recalled. My lord. The order is at page number 18, my lord. 6824, my lord. Relevant para is para 4, my lord, page number 19. On IA 224 for recalling the order dated 31/5/24 was filed by the learned Dhananjaya. This court was on 23/7/24 since the R. Krishna Learned Council, whose name is indicated in the cause list, was absent. Urgent the matter on 30th/7/24. IA 224 filed by the Dhananjaya Learned Council for the recall. The order dated 31/5/24 was allowed, and the order dated 31/5/24 was recalled. The petition was restored to file on a cost of rupees 2,000 rupees. At the time of passing the order 30th/7/24, the petitioner's counsel did not bring the notice to this court about the previous orders passed and what transpired after the filing of the IA 224. Now the wakalat is filed by the R. Krishna and also the Dhananjaya, indicating the R. Krishna has no objection to Dhananjaya to appear along with him. On 5/8/24, this court heard the arguments on merits advanced by Hanuman Rai for the petitioner. As on the 30th/7/24, Dhananjaya, the council should have been fair enough to bring the court to mention about the above narrated facts. Having not done so, IA 224 was allowed. The petitioner, without having power and without any authority, he has filed the
So
IA
the
two
matter is
24, hence the order dated was recalled. Accordingly, the order dated,
matter is restored to his file
yes, my lord.
on cost of 2,000.
Yes, my
That
lord.
you are challenging,
Yes, my lord.
dismissed.
My lord,
What is wrong? It is restored.
my lord, both the advocates, Dhananjay and Krishna, is filed the same wakalat, my lord. Wakalat. Same advocates, my lord. Myself is Dhananjaya. My senior is the Krishna, my lord. On that day, I was not there. He is filed the application. Both were one and the same, my lord. Only the matter is heard, parted matter, my lord. I sought for restoration of the writ petition, my lord. Both have power, my lord.
So 31,524 order was what? What was the order?
Both have filed the wakalat, my lord. During the 1 month is not in the station, my lord, I was abroad. During that time, my lord, my Krishna is filed the application.
It's a 31,524 confirmed. So in this IA number 24, who appeared? IA number 2 of 24, who appeared?
Both were filed, my lord. Both were filed, my lord. Krishna and Dhananjaya. Both were filed, my lord. Same office, my lord. Krishna is my senior, my lord.
Krishna Iyer.
Krishna is my senior.
After retiring, how you can,
No, my lord. Only he is abroad in a few months, my lord.
no. I see it's professional misconduct.
Permission.
You please come to paragraph number 1 itself. See, that's why,
My lord, at the time of first paragraph. At the time of further hearing, this court noticed that the order sheet that the petition was dismissed for.
you come to page number, what is it?
19, my lord.
18.
18, my lord.
Come to page number 18.
Oh, yes, my lord.
Last 4 lines you read.
But you are both.
Bottom, my lord. My lord, IA 124 was allowed.
No. When the matter, yeah, next sentence. No, IA number 1 of 24 was allowed.
And the order dated 22/24 was recalled. When the matter was listed on 2/4/24, on the submission of the learned counsel, the Dhananjaya, his name was deleted from this cause list and the name of the learned counsel R. Krishna was shown. On 18/4/24, the matter stood adjourned. When the matter was listed on 30th/5/24, due to the absence of the learned counsel R. Krishna, the matter was directed to be listed for the dismissal. On 31st/5/24, due to the absence of the petitioner counsel R. Krishna, the petition was dismissed for non-prosecution. IA 4. IA 2/24 was recalled. The order dated
IA 2 of 24 for recalling the order dated 35/24 was filed by P. Dhananjaya once again.
Yes, my lord.
Look,
yes, my lord.
First P. Dhananjaya says
You are P. Dhananjaya?
Yes, my lord.
You say that you are not appearing in the matter.
My lord.
Give-
My lord, I was in abroad, my lord, sometime.
It does not indicate, sir. It says that you are present and you requested that name of R. Krishna to be shown.
No, my lord.
But you belong to, both of you belong to same office.
Few days was not in restraint. That is why sometimes the cause list was served to
Both
the
of you belong
Dhananjaya, my lord.
Kindly listen.
Yes.
Both of you belong to same office? Both of you belong to same office?
Yes, my lord. Both are selling the office.
Then
Even
why you
the
are fighting
last
then?
parasol, last parasol.
Why you are fighting then?
No, my lord.
Not fighting.
My lord. Just
Fighting for what in this petition? We are not, at least I am not able to. What do you want? You want restoration of the matter? Restoration of appeal?
Yes, my lord. Restoration of the WP, my lord. I sought for restoration of the WP, my lord.
Now you are appearing or Krishna are appearing?
Just below the term. Now the vakalat is filed by the R. Krishna and
Dhananjaya
Dhananjaya,
appearing or Krishna
indicating R as the no objection to appear along with Dhananjaya, that is their my lord, to appear along with him. Only I sought for restoration, my lord. Matter is.
Not showing the petition.
Sorry, my lord.
Have you filed the wakalat, sir?
Yes, my lord. In both cases,
You know, in this writ appeal, is
yes, my
wakalat
lord.
filed?
Yes, my lord.
Huh?
Yes, my lord. I filed the vakalat, my lord. Yes, my lord.
Where is the affidavit of the party?
Party is my lord.
Where
Myself.
is the affidavit of the party?
But why don't you file review application? That you have.
Wakalat is
My lord. Is there, my lord? Is there?
Hmm?
Both are signed, my lord, in vakalat.
That is what I'm telling from the beginning, that why you are fighting being in the same office.
No.
It is usual for you.
Sorry, sorry. Sorry.
Now there are two signatures in one wakalat.
Both are,
So both of you are appearing.
both are signed, my lord.
Then
My senior and myself, my lord. Both are filed, my lord.
appeal is admitted, impugned order is stayed.
Yes, I restore the.
No, not restored. Appeal is admitted, impugned order is stayed. Whatever it is, effect is it. You argue the main appeal now.
What's up?
Official verify that Mr. Dhananjaya has filed his wakalatnama on behalf of the appellant or not. If filed and the wakalatnama is regular, the appeal shall be listed for admission here.
What's up?
No.
Number 39.
Check on.
Who's stay alive? Just to verify the-
Who is appearing for respondent? This is very clumsy. Who is appearing for respondent? Hello, this. Yes. So list tomorrow and inform the other. List it tomorrow. Tomorrow at 2:30 and inform that. Dhananjaya should remain present at 2:30.
Number 39, state appeal.
In 39, Lord's amendment was allowed on the last date of hearing. Lord's memorandum of amended appeal, my lords, was not filed by oversight. May be permitted to file the memorandum of amended appeal, my lords, in the registry. And my lords, we have filed an application for additional documents. Today, my lords, they have served objections, my lords, along with documents.
This is that COVID.
COVID, my lords,
Yes.
PPE kit matter, my lords. My lords, on the last date, my lords allowed condonation of delay application, application, my lords, for production of documents, and my lords, application for amendment.
Application for amendment.
Order sheet wrongly reflects that it's allowed. At last date, because they opened the sealed cover. Supposed to be.
Has it been allowed application?
You should have filed a suit, no, sir?
No, my lord, I'll tell you, lordships, my lord, what has happened is before Justice Dikunna, everything is suppressed, nothing, no documents were produced. In fact, my lord, I'll point out.
No, I'm not on that.
Admitted, my lord, amount. They have admitted it, my lord, in innumerable records and documents. That's why, my lord, learned single judge, my lord, directed them, my lord. In fact, they did not even file objections before the learned single judge. And I'll point out, my lord, Justice Kunna's, my lord, this report cannot even be admitted, my lord, in the light of 3 judgments of the Honorable Supreme Court of India. At any rate, my lord, what I can suggest is, my lord, I have got my objections, my lord, I'll point out. All these, my lord, were placed before the learned single judge. Your lordships can, my lord, do one, my lord, subject to my being corrected by your lordships. Your lordships can set aside the order, demand it, let the learned single judge look into it, my lord, including his additional evidence. I have no problem. Otherwise, my lord, I'll argue, no difficulty. In fact, my lord, there are documents, my lord, which they admit. They, my lord, suppress everything from Justice Dikunna. They, my lord, Justice Kunna, my lord, in his report says, that's why, my lord, they don't give the whole of the report. They give him only, my lord, limited copy. What is filed before your lordships, my lord, the whole of it. Anyway, then, my lord, before the learned judge, Justice Kunna, nothing is placed. And he says, these, it is not there, that is not there. And, my lord, I'll point out, everything was there. They, my lord, don't place, my lord, files before him and get an order. After, my lord, the writ petition is filed and, my lord, certain
No,
orders are
the
passed.
only question is it's a contractual.
My lord, I'll point out, there are judgments which have held, if there's an admitted amount, my lord, writ is maintainable.
No, provided if they had filed their objections and if they had stated, yes, it's an admitted amount.
But no, when the learned, my lord, additional advocate general, my lord, not this learned additional advocate, another additional advocate general, he appeared, there are interim orders passed. I'll point out.
Lords, but
I can only suggest this, subject to my being corrected. Instead of, my lord, I'll point out this. Instead of all this, your lordships can, my lord, set aside the order, remand it to the learned single judge, let him consider it. I have no problem. If, my lord, I am not entitled to, my lord, I'll go. But then I'll point out that, my lord, they suppress every material fact.
No, if they dispute the
Lord,
fact,
they don't dispute. That's what I'm trying to submit before your lordship. They have never disputed before the learned single judge. Here they come and dispute. Why? Because, my lord, they say there's a commission report. Commission report is, my lord, absolutely, my lord, lopsided because they deliberately did not produce material, the delivery challenge. He says only list is given. Delivery challenge, my lord, sealed as produced before the learned single judge. Sealed, my lord, signed. Hospitals have received. Everything, my lord, they suppress everything from Justice Kunna's Justice Kunna commission. That's why, my lord, I have got everything here. These were produced before the learned single judge. That also they don't produce in the appeal memo.
Insofar as
Sorry, my learned judge probably does not know.
No, it's not that, my lord.
So
I'm
you
seriously disputing, my lord, the submissions that they're making.
Referring to which report? My lord, they have filed, my lord, an additional report called, my lord, Justice Kunna, my lord, who was a former judge of this honorable court. But this is not, nowhere referred in the order of the law.
No, my lord. They have filed it before your lord.
It is subsequent
development.
It is subsequent development.
Last date of hearing, my lords
And
permitted
I'll
us to
point out-
open the sealed cover, my lords, and the report is taken on record.
Single judge.
What is this?
This, then this one. Page 121.
Is the one which I have.
The said submissions, my lords, that the
My lord,
senior is
please
making
have a
with
look
all
at what
respect,
the learned
may not be
single judge's
factually
order.
correct, not be factually
No,
correct.
this report was filed between the disposal and the filing.
Please,
of it.
please, my lords.
That is an additional document.
That's an additional document, my lords.
By whom it is filed? By you?
Please, my lords, it is
Before your
part of,
lordships.
it is part of the application for additional documents on
Now-
the last date of hearing. My lords are pleased to open the seal cover, permit, my lords, have taken it on record. And my lords directed us to give us a copy, and we have given a copy. Now, my lords,
Lord,
they're
with the
coming up with a
greatest
500-page
respect,
objection.
Don't give the
No.
whole of the copy.
No, no, it is
See-
only the relevant extract, my lord. It
see.
relates, my lords, to several other aspects of the matter with regard to PP
He
kit, my
filed
lords,
the
the
whole of
entire,
it.
my lords, one submit.
Yes, yes, my lord.
Incidentally, Mr. Hola relies on the same report.
No, he is saying, no, he, my lords, what sir is saying
That
is,
there is an admitted amount.
My lord, what has
There is no-
happened is, they, my lord, before Justice Punna, they don't produce, my lord, the documents.
no, which we are disputing, we have produced.
I'll point out here.
I will also point out, my lords.
I've given
My
a
lords,
copy, my
in
lord.
fact, what had happened
This
was,
is what?
This is, my lord, objections to their application, my lord, and additional document.
which we have received.
Everything, my lord, is suppressed from him. In fact, I'll point out, my lord, if your lordships look at, my lord, the learned single judge. This is what he has said, my lord, learned single judge. Learned AAG Huilgold, appearing for the respondent, does not much deny the discharge of the contractual obligations undertaken by the petitioner. This is, my lord, interim orders passed. Thereafter, my lord, no objections are filed. And, my lord, ultimately, my lord, the learned single judge, my lord, passes the order. And thereafter, my lord, they appoint, my lord, Justice Kunna, and then, my lord, get a report.
My lords,
And what do? They suppress every material. There are, my lord, sealed documents which were placed by us before the learned single judge. That also they don't place before the learned, my lord, commission. And, my lord, the admission, the director herself says, this is the, my lord, amount, my lord, that I am entitled to. That also is suppressed from the learned commission. Everything is suppressed from the commission. And, my lord, the Supreme Court of India has held that, my lord, commission report can't even be taken as evidence. My lord, I've got those judgments, but I don't want to stand on that formality. If your lordships, my lord, are inclined, your lordships, my lord, set aside the order, remand it, let the learned single judge look into it. That's all that I would say.
Lords,
I have no problem.
Lords, that is a fair submission, my lords, but only thing with regard to the maintainability of the writ petition with regard to disputed question of fact, that also may be kept,
That may be
left open,
my lord. I have
because
no problem.
I am covered by, my lords, the division bench judgment of, headed by my lords, may I just pass on, my lords, where in a similar fact situation, where, my lords, the learned single judge allowed a claim of monies to be made and left the rest of the matters to be taken before the arbitrator. And in this case, learned single judge says, with regard to interest, you can go before the civil court. If my lords, the logic, my lords, with regard to interest applies, it applies, my lords, for the whole dispute. And not only that, the learned single judge, my lords, allowed the writ petition only because of an affidavit filed by them, which is in paragraph 19, page number 19, my lords, where they say that we are kindly see, my lords, page 19, my lords, of the paper book. Affidavit was filed by them that we will take the balance amount subject to indemnity in respect of the inquiry that is pending. Now, only on that ground, my lords, it was allowed. So now, my lords, I have the material to show them.
See, if you have filed just one line objection,
Please, my lords.
that it is disputed, there is disputed question of facts involved, and it cannot be decided in this particular writ proceedings.
Please, my lords.
They would have gone to the civil court.
No, my lords, we had that objection.
But you suffer that order, now limitation is up. No, listen, there is complacency on your part also.
No, para 5, my objection on this aspect is recorded specifically by the learned single judge, my lords. I understand, my lords, that formally objections were not filed and my lords are saying one line objection could have sufficed. But this aspect of the matter that we are disputing the liability is recorded by in paragraph number 5 of the impugned order. And, my lords, with regard to limitation, my lords, exclusion under section 14, my lords, will certainly apply, is my respectful submission.
In a suit.
In a suit, exclusion, my lords, with regard to time spent, my lords, in court without jurisdiction under the Limitation Act. Whatever time was spent, my lords, in the writ court, my lords, and before this honorable court will certainly get excluded, my lords. But be that as it may, my lords, we have enough material to show. Now, may I just pass on, my lords, this division bench order, my lords, of my lords.
My lord, can I, my lord, give this, my lord, including the learned single judges, my lord, interim orders where they admit.
No, admission is with regard to the quantity. On the last date, my lords have noted, quantity delivery, my lords, is not, it's about the
No, my
amount.
lord, even that,
It is-
my lord, is
it is-
disputed before Justice Kunna, and he
No,
says
no,
nothing is
no,
fixed.
no, no. It is not about this contract. I will be able to demonstrate. Justice Kunna has said in respect of this contract, it was without a tender, and in respect of the amounts. This is a second wave COVID matter, my lords. First wave, my lords, it was supplied at 1,300. Second wave, my lords, rate had fallen to 400. Same quotation supply order was issued, and then, my lords, we have taken action against our officials. It's not that I'm trying to, my lords, only say something against their contract. And, my lords, one more aspect that was pointed out was contract was with the second petitioner. Petition is filed, my lords, by Prudent, which is not even the my lords,
Even that is
the
not
successful
correct.
bidder. And
Even-
no, even there is a letter of authorization which Justice Kunna's committee's report says it is only restricted, my lords, to the contract. My lords, they have just handed over all these documents to us.
You have produced that report here?
Please, my lords, it is part of in the seal court. My lords opened it on the last day.
They file a report of 100 pages. Give me, my lord, this.
ಇಲ್ಲ, ಇಲ್ಲ, ಇಷ್ಟೇ
Where
sir.
is that?
Cover ಅಲ್ಲಿ ಇಷ್ಟೇ ಇರೋದು.
Huh?
ನಾನು ಕೊಟ್ಟಿದ್ದೆ ಅಷ್ಟೇ.
No, along with the application to.
Additional documents, my lords.
नहीं है इसमें कहाँ? Document of tender. Upon contract, where is that?
No, that's it. You have to go step by
Additional
step.
facts and documents.
Please, my lords, along with
So-
that,
So you produced contract
Document number
form,
7.
purchase order, notification, that's ACS committee report.
yes.
Along with translated version, notices, sealed cover.
Please, my lords, on the last date, my lords, were pleased to open the seal cover and my lords taken that report on record. I'll just read 2 paragraphs, my lords, I'll be able to demonstrate. Or, my lords, insofar as if it is the question of with regard to maintainability is kept open, my lords, because at the
When you have the additional documents and not really report, you send it back to.
please, my lords, but maintainability question may be kept open, my lords.
I have no problem. Let the learned single judge look into it.
Regarding a contractual dispute,
All issues.
all issues, please,
All issues.
all issues, please, my lord.
Content.
Grateful, my lords.
So tomorrow we'll pass you.
Please, my lords.
I don't have reflections.
I know.
Please,
It's
Not
already-
because of, not read there. Tomorrow at 11, either
Please,
we'll declare the order.
please. But there are judgments of the Supreme Court which have held that kind of a report is not admissible. Anyway, I don't want, my lord, stand on that formality, my lord. I don't want to stand on that.
You want to
formality.
observe us, then we'll observe both,
No.
that
No, all contents left open is what, my lord, will then exclude my lord, everything. I leave it at that.
Grateful.
Number 40. B. Ramesh.
For 72 days delay is there in filing the appeal.
delay is there.
72 days, my lord.
Count down to be count. Delay will count.
Please.
There is nothing in the appeal.
My lords, for this reason,
Suit is pending still. The
my lords,
case is-
secondary, my lords, the order passed by another single judge was misled by the respondents hearing on the count that this land is an agriculture land. My lords, it is not an agriculture land. It has been assessed to tax by the Gram Panchayat, and the Kata has also been issued in favor of my vendors. My sale deed is of the year, my lords, 2010. The respondent number 12, who claims a title under the very same vendors, my vendors, is at annexure, my lords, E, page 112. My lords, he purchases the property, my lords, site. My lords, kindly refer to, my lords, the annexure E, my lords, page 112.
My lord, scheduled is at page 137. My lords, once it is assessed to tax, question of mutating the name, my lords, in respect of agriculture land, stating as it is an agriculture land does not arise, my lords.
All that we'll consider next. Delay is gone.
What's any short date, my lord? What's any short date?
Short date means it will go to 24th March.
What's earlier to that, my lord? Earlier to that, my lord?
Well, no chance, Mr. There are a lot of matters are coming up. 21st March.
Much of it.
We'll dictate in the chamber.
Item number 41. Item number 41. The date may be fixed, my lords. Objections, they have, state has to file their objection. This is pertinent to that.
My objections are ready. My objections are ready. I'll file it in the counter tomorrow and I'll serve a copy on the, may I request your lordship to kindly have it next week, no, if it's convenient to the court, or any date.
Any date, my lord, any date.
1st April.
Much obliged, my lord. Interim order.
One submission, my lords.
Lordship, serial number 80.
Serial number 96.
Serial number
my lords.
80. Any date, my lord.
Your Lordship, item 40.
Serial number 96, my lords.
Item 44, Your Lordship, has come up 4 times before this bench without being taken up. There's some urgency if I could request as short a date as possible.
17th.
I'm deeply.
One
My lords,
submission. my
item
lords.
number 96, my
Number
lord.
80.
Item 96, my lords, it is, my lords, they have been served. It is a very short point, my lords. I need only 5 minutes of my lord's time. I request, my lords, next Monday, my lords, if it may be convenient to the court.
Serial number?
96 minutes. It is a very short point. There is the order, the judgment passed by the learned single bench has not been complied with in part, and tomorrow is the last day for the second compliance to be made, which has not also been done. So I will have to file another contempt as well related to the same judgment. So for this, my lords, may I request next Monday?
Monday.
I'm grateful.
Serial number 136, my lords. Lordship, with regard to the special Tashildar, my lords.
Which is that?
The Lordship had passed order to file affidavit on behalf of the Assistant Commissioner. Now the order has been passed, my lords. The special Tashildar post, my lords, which was in charge, my lords, is given to Tashildar, my lords.
You have not passed the order. Wanted you to come at 11.
I just reported, my lords, that now order has been passed, my lords.
So you said, rightly said that you are not taking instruction. No, other side is not here. Come at tomorrow.
Please, please.
Item 49.
Only thing on your part remains compliance to be
Please,
done by
no,
the
that
person in
we'll
charge.
do that, my lords.
My lord, may I make one submission, my lord? Item number 50, my lord.
Yes.
My lord, the interim order has to be extended, my lord. I appear for the petitioner.
Wherever it is operating, everywhere it will be extended.
Gratefully.
My lords, item 49.
Number 107, my lords. Matter pertains to the 1,512 EWS families, my lords. The bank has initiated proceedings to take over the land. We filed an IA seeking status quo, my lords. May be heard as soon as
All matters will be heard.
Please, my lords.
Lords, item 40. Item 49.
Yes, Mr.
My lords, item 49. My lords, your lordship may kindly recollect regarding the setting up of a cow slaughter, my lords, near the airport without, my lords, NOC. That your lordship may kindly consider.
Take a date.
My lords, early date. Grateful.